Hi, Mel. Thanks for getting it started.
Okay, I'm just putting the link on the website.
Awesome. Thank you so much. All right. Thank you. Thank you. Thank you. Thank you. I'm going to mute myself and go get some water and eat breakfast. Hi there. Oh, excuse me. Can you let me know your name and what case? I think you need to unmute yourself. Nope, I cannot hear you because you are muted on your computer, I think.
How's that? Can you hear me now?
There you go. Yep.
Excellent.
And your name is?
Last name is Piche, Piche.
Yep.
First name is Rich.
Yep. For Oceanside. Yep.
Yes.
Okay. Thank you for letting me know. I'm just going to rename you on here and you'll just stay muted till it's time for your case.
Okay.
Thank you.
Thank you.
Yep. Hey, Brad, I'm just going to shut the door so I don't bother you. Hi, Mr. Peabody. Maybe when you get your microphone going, you can tell me what case you're here for. Oh, you're muted. Nope, you're still muted. You probably need to touch a button if you're on a, there you go. Now you did it. Now you're not muted, but I can't hear you. So I'm guessing maybe your microphone, if you turn your volume up. Oh, try again. Maybe it was me. Try saying something. Or don't. Mr. Peabody, why don't you try saying something so I can see if the volume works? Okay, thanks for letting me know. I appreciate it. And you may want to try looking at your what microphone you have in your system to see if it's set up with the right microphone. You can't hear anything. Okay. Hi, Miss Fairbanks. It looks like you're in the same place as Mr. Pitchy. Miss Fairbanks, can you tell me what case you're here for? I can't hear you. Can you take your microphone? There you go.
Willett versus Oceanside.
And you're representing?
I am here as a board member representing Oceanside.
Okay. Thank you.
There's my,
You gotta turn the volume.
yeah, I gotta turn it down.
I'm going to keep you muted for now, and you've got some feedback with Mr. Pitchy.
I know we're working on that.
Okay.
Thank you.
Good morning, Commissioner Duson. I'm so glad to see a commissioner here. I was starting to get concerned.
Oh, are we having a meeting today?
We are, yes. So far, you're the only commissioner, so thanks for joining us.
Well, I'm happy to stand in on behalf of my fellow commissioners.
Hopefully, at
morning,
least
everyone.
3 others. We're expecting 3 others today, so
Cool.
hopefully they'll get here soon. And Commissioner, if it's okay with you, I'm just going to rename you on the things to say Commissioner Jill Duson. Is that okay?
Well, okay. You don't want to put in good looking or
There's a lot of things I could put in there, but I'm going to go with Commissioner.
I appreciate it, Madam
Yes.
Director.
Yes, well, maybe will do, but thank you. All right.
So let's see. I got all my electronics.
Good morning, Mr. Smith. And you are here for, is it the Willett case?
Yes,
And you're here for Miss Willett?
that's right.
Okay, thank you.
Thank you.
Two commissioners, very exciting. Okay. Good morning, Commissioner Ashby. Glad to see you. You're still muted, but I know you're there.
I never do that. Good morning.
I still do it. A year.
I make fun of people. I make fun of people who do that. I can't believe I just did that.
I do it all the time. All right, if you don't mind, I'm just going to put Commissioner Jeff Ashby on there just so everyone knows who everybody is. We should have 2 more commissioners joining us. We should have Commissioner David and our brand new commissioner who just got sworn in Friday afternoon, Commissioner O'Brien. And Commissioner Whitworth, as you know, Commissioner Ashby can't be here today, so Commissioner Ashby will be chairing the meeting as the next most senior. Good morning, Barbara. Hi, Alice. Good morning, Commissioner O'Brien. At least I think that's Commissioner O'Brien, since we have not met. Nope, can't hear you yet. You are muted on your end.
Hello?
Hi, yes, now we can hear you.
Hi.
Hi, you must be Julie O'Brien. Is it Julie?
Oh,
or
hi,
Julie?
Amy. Yes, yes, yes. There we go.
Would you prefer
Hi,
Julie,
everyone.
Julie or Julianne?
You know what? It's always been Julie. My actual name is Julianne. So when I went in the legislature, I said, I want to be a new person. So I wanted Julianne. But the only people who call me that are people that I know from government. So let's just say Julie.
Okay. Well, it's lovely to see you there.
You too.
And in a minute, you can see two of our commissioners are here already. We have Commissioner Jill Dusson and we have
Hi, Jill.
Commissioner Jeff Ashby, whose camera is currently off. And we will have one more commissioner. And up there's Jeff.
Hi there, welcome.
Thank you very much.
And Commissioner Ed David should be joining us, and Commissioner Deb Whitworth can't be here today. So Commissioner Ashby will be chairing the meeting today. Jeff, your question, we are taking the second case, Richards Cretlow. We're taking that first on the assumption that there will be a host of interpreters. So,
Thank you.
yes. Look at that, a quorum. That's nice.
Great. Thank you. I need to say that until early this morning, our internet has been very, very shaky. So if I go off, I go off. Okay.
Okay, well, I appreciate the warning. I think that has probably happened to most of us at some point where you just disappear from a meeting, and sometimes people notice and sometimes they appear not to even notice.
You have
That's
the
happened to
dial-in
me.
number.
Yes, that's a good point. We do have, for anyone who does get bumped off, we have on the invitation that we sent you, the email, there is a phone number. So you can always dial in on a phone if somehow the video fails. And I think we have our first interpreter. First table interpreter. Good morning. And I think your team is it MJ is going to be your team?
No, Mary.
Okay, yep, that's right. Thank you. So we'll be relying, first we're going to do a business part of the meeting at 8:30 and we'll start the cases at 8:45. And assuming that everyone is here for the first case, I'm sorry, for the case that the interpreters are here for, we'll take that one first. But so far, I believe we have the attorney for the complainant and one interpreter, so we're still missing quite a few people. And I'm getting a message saying there's no table interpreter today, just proceedings. So we're still missing the respondent and respondent's counsel and another proceedings interpreter. Oh, there's another interpreter coming in. So we're still missing the respondent, and I don't know if complainant is joining us, but so anyway, we still have some time. I just wanted to let folks know where we are at the moment on that case. And for Mr. Strzok, I see you here. Good morning, Mr. Strzok. I hope you don't mind that we're going to take the second case first, just because whenever there are interpreters, we like to try to speed that process along as much as possible since we are all paying by the hour.
Even if you weren't paying by the hour, it's totally understandable and no concern whatsoever here. Thank you.
Great, thank you. Good morning, Mr. Rice. And Ms. Aiello, thank you for letting me know that complainant in your case is joining us. That's what I thought. Good morning, Ms. McKay.
Good morning, Ms. Neerson. Good morning, everyone.
I was just letting folks know, I think we don't have Mr. Richards Cretlow yet or respondent, but we're assuming we do have everyone here. We'll take your case, the ASL case first on the case agenda. So we're still waiting for a few folks.
Very good.
And we are still missing one commissioner that I think is joining us. Good morning, Mr. Finberg.
Morning.
Morning. I just wanted to check in with you, assuming that we have all the parties and attorneys for the Richards Cretlow case. We are probably going to take that case out of order and take it first, if that's all right with you.
I have absolutely no objection to going first.
Getting out of here first? Yeah, I didn't think so. Okay. We'll keep everyone muted for now. Good morning, Commissioner David.
Good morning. How are you?
I'm good. How are you?
Just fine.
Well, I don't know if
Beautiful
it is a beautiful day. I don't know if you can see, did we lose? Oh, Commissioner Julie O'Brien. This is Commissioner Ed David.
Hi, Julie. Nice to meet you.
Julie just got sworn in Friday afternoon.
Oh, wow. Okay.
And then Commissioner Whitworth is unable to join us today. So that's our full complement of commissioners.
Oh, wow.
So Commissioner Ashby will be chairing the meeting today. So good morning to the folks who just joined us. Mr. Beard, if I could just ask, is there a case you're here for?
Yes, I'm here with David Weber on the Dr. Akasi case.
Oh, that's right. I completely forgot. I don't even know what I'm thinking. Yes, thank you so much. I don't know where my head's at.
No problem.
Hi, Bob.
Morning.
I know you're just Bob, but I'm going to put your whole name on there. I would put the dude, but that seems a little informal. Commissioner Ashby, are you ready?
I am. Good morning. I'll call this meeting of the Maine Human Rights Commission to order. We have been provided with an agenda, and I'm looking for a motion for adoption of the agenda.
So moved.
Second.
Second. Moved and seconded. Is there any discussion? Hearing no discussion, I'll take a vote.
Yay.
Let's see. All in favor?
Commissioners, if you could verbally say yes also, then I can see your hand and hear you.
Yes.
Yes.
Thank you. You spared me having to call you by name. The agenda's been adopted. I didn't bifurcate. Do you feel, Amy, we've adopted the consent agenda, or do you want a separate motion?
No, I think it's all one together, so I think we're good. Thank you.
Excellent. Great. Thank
Sorry.
you.
Oh, actually, yes, I apologize. Thank you, Kristen. Now that Mr. Richards Kretlow has joined us, we need to get the interpreting put in place. If we could just pause for a
I
minute.
do not, yes, I do not see Mr. Kretlow Richards, so one moment.
I am
Steve is
told-
here. He's got the orange shirt.
Yeah. So
Oh,
for
there he
the
is.
hearing folks, we need to wait for a second. The process of getting interpreters and making this work can be a little complicated on Zoom.
I'm good, Mr. Kretlow says. I can see the interpreter.
Okay, great. Then back to you, Commissioner Ashby.
Great. Thank you. We're looking for a director's report, Amy.
I think we skipped adopting the minutes from the.
We did. Thank you. We have been provided minutes of our April 12, 2021 meeting. Is there a motion to adopt the minutes?
So moved.
Second.
Moved and seconded. Any discussion? Hearing no discussion. All in favor, please raise your hand and say aye.
Aye. Aye.
Yes, thank you.
Commissioner Ashby, did you vote?
No, aye. Thank you.
Thank you. Yeah.
I think that's all of us, so I
Yes.
won't ask for abstentions. Now, thank you. Amy, we're looking for a director's report.
Yes, happy to do so. Good morning, everyone, and a special welcome to our newest commissioner, Julie O'Brien. This is the first time we've technically had 5 commissioners on the commission for quite a while, so it's very exciting, even though we only have 4 here today. For administration, we are still in the process of hiring for the vacant secretary associate legal position. For compliance, there's actually quite a bit to report. So since our last meeting, you have a memo from me, a cover memo saying the status of reasonable grounds cases. And it shows that there are 5 cases currently in the process of being conciliated. It shows 8 unsuccessful conciliations and 4 successful conciliations. So those are cases that resolved within the 90-day conciliation period provided for in the statute. And then 1 post-conciliation agreement. That's a case in.
Amy, I sometimes have trouble finding which page you're referring us to.
Yeah,
with
so
that
I'm
report.
looking at, it looks like this, Ed. It's
Yeah,
a
but
one page.
in the breakdown that they give us, is it under business section?
Yes,
Yes,
they would be
it's
in
the
business,
last
yes.
item in
Okay.
business.
Okay, all right. Last item in business is motion. Okay, council status. Thank you.
Yes. So it shows that there are 5 cases that are currently, and thank you, Commissioner Dusan, 5 cases currently in conciliation, 8 cases in which conciliation was not successful since the last meeting, and we sent the notice saying conciliation has not been successful. 4 cases that conciliation was successful, and 1 case that settled after the conciliation period. However, since the time I sent you this, one of the cases that we did resolve on Friday afternoon at about 4 o'clock, the respondent essentially reneged on their agreement. So I will, there's nothing for you to approve. There's 1 agreement that I will not have you approve because it can't be binding since the commissioners haven't approved it yet. So if you don't mind, I'd like to walk you through the other 4 agreements, just so we're clear about what they are. The first agreement you have is it, and I will need a vote just so we have this in mind, a vote either on each of these or all four of them together to be approved. So the first one is for H200373, Adams versus Libby. And you all have a memo from me along with the agreement itself. There's also E190019, which is Varney, VARNEY versus Planet Fitness. And you have a memo from me along with the agreement itself. The third case is H200390, which is Felix, FELIX versus Friend and Webb, WEBB. And you have from me a memo outlining the agreement and the agreement itself. And the other agreement that continues is E190286, which is Schwartz, SCHWARTZ versus Elior, ELIOR. That's the post-conciliation agreement. The one that fell through on Friday afternoon and that you are not approving is H200399, Garrett versus Larkin. So that one we are not approving. So at this time, I'm happy to answer questions as needed, but otherwise ask that the commissioners vote to approve the 4 continuing agreements. So the ones presented to you, but not Garrett versus Larkin.
I'll entertain a motion on all 4, and if someone feels we should take them separately, we'll deal with that in discussion.
I'll second the motion. Oh, I'm sorry.
I'm
You
sorry.
weren't making the motion. Mr. Chair, I would offer a motion to approve the 4 cases, Varney, Schwartz, Felix, and Adams in one motion.
Second.
It's been moved and seconded. Any discussion? Hearing none, I'll take a vote. All in favor of the motion, raise your hand and say yes. Yes.
Yes.
Commissioner O'Brien needs to unmute.
Commissioner O'Brien, thank you, Commissioner David. If you don't mind, it helps to hear orally, auditorily, just to make sure that I've got all of you.
Yes.
Okay, thanks so much. All right, and
I
so
think I saw that was unanimous. Is that correct?
Yes, it was. Yes, it was 4-0. Thank you. Next, let's see. For investigation, in April, there were 76 new charges. And I have to say the numbers are just going up and up and up. And particularly housing has been a lot. And we think it's going to be that way for a while. In April, I administratively dismissed 16 complaints. And that number is probably going to stay up for a while just as a way to manage our caseload. And for predetermination settlements, and you don't have, just so you know, you don't have some of the reports that you would normally see on administrative dismissals and new charges because we get those reports from the Equal Employment Opportunity Commission, one of our federal partners, and they have taken that reporting tool offline. It's been failing for years, and they finally have dispensed with it, and they are putting a new tool and training. They've created a new tool and they're training people on it. And Melody has done the beginning training, but it's not ready for prime time yet. So essentially, the reports you have are what we can get together, and we are extracting data from it. So, Jill, was that? Sorry, Commissioner Doosan, was that a question that you had?
No, ma'am.
Okay. For administrative dismissals, there are 16 since the last meeting. And for predetermination settlements, there were 19 in April with benefits of just about $483,000 to complainants. So the last item that you have, let me back up. The next item that we would normally hear would be litigation. I would ask that we take that after executive session. And For new business, you do have in the business folder a packet that shows all of the written testimony we have submitted. That's probably not even all of the testimony. There's probably been others, but it's just been an extremely fast and furious legislative session. So we try to keep you informed. It's hard to do in real time. So that's a summary of the ones that I think we have submitted so far. I think there's 8 of them. We still are attending lots of work sessions, including this week. And the commission's bill, our one agency bill, which was a bill we introduced 2 years ago and got kicked up and down and died in the pandemic, that had its public hearing on Friday of last week. And I don't actually know when the work session is. My guess is it will probably be shoved in sometime this week. Also, the budget, as you may recall from a prior meeting, the governor had put through a baseline budget to keep government operating and was going to be addressing agency-specific initiatives. And now is the time when the governor has put in her change package to address agency-specific initiatives. And we are, as of, I think it was Friday night, maybe it was Saturday, I don't remember. Melody was dealing with some of the, correcting some of the initiatives that continue to be sent to us that we correct and send back and correct and send back and correct and send back. And I think the change package will, I think it's on a schedule on Thursday at appropriations. The initiatives have already been approved by judiciary. So it's unclear what exactly will be happening, but we are as on it as is possible. And I believe the initiatives that were approved through judiciary, at least as of the last I heard, are set to be in the change package as far as we know. 2 other items I would mention. One is that I think I will be going through my annual process of setting meeting dates for 2022. This is about the time of year when we do them. And so if commissioners are aware of any conflicts you have for Monday morning meetings in 2022, we try to hold them every 5 to 6 weeks. Or 4 weeks earlier in the year before our federal partner deadlines. Please do let me know, and I'll run a proposed schedule by you before we get to adopting one. And finally, we did, through a HUD grant, it was a CARES Act grant, we put together, we had previously done a short public service announcement about the fact that COVID can exacerbate existing sort of MHRA issues or can create new MHRA discrimination issues. We had done a short public service announcement that turned out great. And we just finished a longer webinar that is intended to be like actually informational about for employment, housing, public accommodations, and education. It's about 12 minutes long, and I think it turned out really great. We have not done a press release for it, but it is now on our website and our Facebook page. And I do encourage you to check it out because I think it did turn out really well. And that's all I had. And now we have exactly 0 time until we start our hearings.
Perfect. Thank you, Amy. Any questions for Amy, anybody? Busy legislative work.
Yes.
Impressive. All right. Well, good morning. I'm Jeff Ashby. And on behalf of my fellow commissioners, I welcome you to this meeting of the Maine Human Rights Commission. Before we proceed with the business of today, I'm asking each of you who may have an electronic device, cell phone, pager, etc., to ensure that they are silenced now. We have additional agendas, including the consent agenda. It's been provided to you or available electronically. The consent agenda is a listing of cases in which no written arguments were made to the commission in the allotted period. The commission, as you just heard, has voted on these cases and they will not be considered further today. Remaining cases on the agenda today are coming before the commission to determine whether reasonable grounds exist to believe that unlawful discrimination has occurred. The commissioners have received and reviewed investigators' reports and any written submissions submitted within the allotted time. No new information or any written materials will be accepted today. Cases will be called in order on the accepted agenda. As I call each case, the party who has submitted a written argument will be called, it says here, to the podium, but you'll be called upon electronically in the Zoom meeting to provide the most relevant arguments in the case. The time is limited to 10 minutes. Time may be reserved to rebut opposing arguments, but the time limit of 10 minutes may not be exceeded. Procedural rules of the commission specify that your arguments may address only 1, relevant factual errors, 2, relevant omissions from the report of facts submitted during the investigation, or 3, relevant issues and questions concerning interpretation of the law. The commission allows parties who do not disagree with the investigator's report to rebut comments made by the opposite party. Please be advised that commissioners may ask questions, and I will ask that you introduce yourself as we call upon you. Thank you. And we are taking.
I could just, sorry, Commissioner, if I could just ask folks, as a general matter, 2 things. Don't mention the names of third parties or witnesses. And 2, because we have interpreters here, I would ask that folks who, if you are perhaps a very fast talker, as I am, consider slowing down. But also if the interpreters need to ask you to pause while they catch up on interpretation, please just be aware that that might happen. And we're going to allot in the case involving interpreters a little extra time if needed to allow for the interpreting process, which normally is simultaneous but can involve some delays for clarification. And also we're going to take this case involving interpreters first to minimize the amount of time that the interpreters are needed unless the complainant wants to stay throughout the meeting, which he is entitled to do. So for the folks who are here for the ICASI case, I apologize, but I did check with Mr. Strzok, but also to Mr. Weber and Mr. Beard. We're going to pause on your case and take it second. So I appreciate your patience on that.
Great, thank you, Amy. The first case then is Stephen Richards Cretlow versus Dingley Press. This is a reasonable grounds case. Is there anyone here on behalf of the respondent?
Yes, Rick Finberg here for the respondent. All set to go?
Yeah, go ahead, Mr. Finberg.
Great, thank you. Well, good morning, all.
If you could just, I'm sorry, Mr. Finberg, this is the interpreter. Amy, we're gonna switch interpreters now.
Yeah.
So just pause
hold
for
on
1 second.
Yep.
We can work out Zoom.
Yep.
Make sure Mr. Cretlow sees the interpreter.
Mr. Cretlow, do you see the interpreter? Okay. Who's speaking? That was Amy. Yeah.
Rebecca. I don't see a Rebecca, he says. No.
Can we make
Maybe
it
can you
bigger?
pin her?
Yep. Okay, so for folks who are at the meeting right now, I'm going to pin the interpreter so that Mr. Richards Cretlow can see her. If I can figure out how to do that, hold on. Pin. How's that? Is that better, Mr. Richards Cretlow?
Oh, yes, he's saying. Mhm,
Okay.
Thank you.
Okay. All right, Mr. Finberg, go ahead.
Thank you. Good morning, all. Again, my name is Rick Finberg, and I represent Dingley Press, the respondent in this matter. I've submitted, obviously, a written objection. I'm going to focus on a couple of the key points, but a brief introduction about my client. It is a commercial printing manufacturer located in Lisbon, Maine. Has been in operation for over 100 years. Generally operates with 4 shifts, with multiple commercial presses operating simultaneously during each of the shifts. Each printing press is a massive piece of equipment comprised of thousands of components, many of them moving at great speeds. And each press is so large that typically there are assigned to each press 4 or 5 team members who, while the press is in operation, are not always within sight line of each other. And so rely on audio communications often during the production process and during emergencies. In addition to the printing presses, this is a large production floor. There are as many as 12 power lifts in operation at any one time, picking up product from each of the presses, delivering supplies to each of the presses, including very large printing rolls. Both the printing presses and the power lifts are equipped with audio bells and whistles consistent with OSHA requirements. As secondary alarms, but not sufficient to serve as primary alarms per OSHA, they also have visual lights blinking on both the power lifts and the large printing presses. The job in question today is the entry-level job of a jogger. The jogger, as I mentioned, is one of 4 or 5 team members at the printing press, and the jogger's responsibility is to take printed material from the stacker, which is part of the press, placing it on the skids for transporting elsewhere. The jogger is also involved in helping to change the printing plates on the presses, to assist with roll setting, and to assist others and serve as the roll tender, which is the person at the end of the printing press dealing with the large roll of paper. The focus really of my talk is on the investigator's final stage of her analysis. It's numbered paragraph 9 of that stage of the report on pages 5 and 6 of her report. It's our position that the investigator made statements of factual error and misapplied the law in all 4 of the components she sets forth in that final stage of the analysis, parts 9, A, B, C, and D. The 2 primary issues in this case are whether the complainant was and is a qualified candidate to perform the job of jogger, and 2, even if the complainant is a qualified individual, was sufficient evidence presented to support a finding of direct threat or safety. It's our position that the candidate is not qualified to perform this particular job. And in addition, we think we provide compelling direct evidence of direct threat and safety that would preclude him from performing the job of a jogger. In terms of the qualifications, the parties concede, the complainant conceded in his admissions that communicating with fellow team members at the printing press is an essential function of the job. The investigator took issue with the fact that we didn't drill down further in the written job description to flesh out what communicating with team members meant, and therefore held that since we didn't include in the job description that hearing and verbally communicating with team members, particularly during an emergency, was an essential function, that our position that it is indeed an essential function didn't hold any water because it didn't show up on the written job description. That's not the law. The law, both the court and the EEOC, frankly, advise folks not to narrowly interpret job descriptions, for one thing, but it's also clear that the job description in and of itself is not the sole basis for determining what is and is not an essential job function. The investigator was required to look at as many as 7 additional factors. Not all are applicable in this case, but there are a few that the investigator completely disregarded. One, according to the EEOC and courts, the investigator was required to consider the employer's judgment as to which functions are essential. There's nothing in her analysis that indicates there was any assessment of that judgment other than parroting in the initial introductory factual background what the essential functions, what we claim they are, but nothing is part of the analysis. she also needed to look at the consequences of not requiring the candidate to perform the function of hearing and verbally communicating. And this was a fatal error because it's clear, especially in emergencies, that absent the ability to hear and verbally communicate, grave harm can occur. There's nothing in her report that analyzes this issue at all. And getting to that primary point of direct threat and a safety issue, the investigator claims in that page 5 and 6 of her report that in talking about safety, Dingley Press merely expressed generalized concerns about safety. I was frankly astounded by seeing this description of the evidence we presented. We presented actual evidence of serious harm at the printing presses to support the safety. And other than mentioning it in the introductory, it doesn't play any role in the investigator's analysis. We presented evidence of a 21-year-old jogger who was killed in a horrific print press accident at this very type of press. Her head was crushed by the press. I can assure you that the family of the decedent and the employees who suffered trauma from being on the scene do not consider this horrific accident one of generalized concern of safety. There's no evidence in the report that the investigator gave any serious consideration to this incident. In addition, we provided evidence of an injury just within the last 2 years in which an experienced jogger, the same job that this complainant wants to fill, got his gloved hand caught in the press. His hand got pulled into the press and got mangled. Because his hand was stuck in the press, he wasn't able to reach the red emergency button to turn off the press. He was outside the sight line of all of his team members, but was able to loudly make a verbal directive to stop the press. Had his team member not heard that directive, his arm would have been dragged into the press, likely mangled, and he might have faced amputation. If that's not direct evidence of grave harm, because that could result from someone not being able both to verbally communicate the issue and hear an emergency directive, I don't think there's any evidence an employer could ever present to satisfy the safety danger that this presents. It is clear that in order to be at this press, you have to be able to hear and communicate with your team members, and told otherwise would present really an unfortunate, would tell all the other team members on this machine that they are required to incur a much higher level of risk in order to accommodate this particular individual. I don't think it's appropriate for us, the commission, or anyone to tell those other employees they have to take on the risk of having someone on the team who can't hear an emergency command and who could not make a verbal emergency command, such as the example I just gave with that jogger. Because of that, I would ask that you reject the recommendation of the investigator and find no reasonable cause of discrimination. Thank you.
And Ms. Neerson will change interpreters again?
Yes, thank you.
Mhm. Okay, thank you.
Okay, so now let me unpin that interpreter and try pinning. I don't entirely understand how this whole pinning business works. Does Mr. Richards Cretlow need to pin it, or do I need to pin it?
Okay, one moment. Yes, this is a little new to myself as well, Mr. Cretlow is saying, so I'm not really sure what I'm doing. I seek any and all assistance.
Okay, I'm just gonna find. So I can pin, if I pin Mary, that makes her picture big for, does that make her picture big for everyone? Or just for Mr. Richards Cretlow?
Not for everyone, I don't believe.
Oh, not for everyone? Oh, okay. All right, so I'm going to pin it. If it helps you, Mr. Richard Cretlow, great. Okay, I am pinning you now.
I'm good.
Pin. Okay. Now let me just check. If I do this, is the interpreter still pinned for you?
Yes,
That's good.
it's good.
Okay.
I can see the interpreter.
All right, great. Okay, thank you. So now, Mr. Finberg, you did a great job. You have like 10 seconds left. Okay, sorry, Commissioner, back to you.
I think it's appropriate to ask commissioners if we have any questions for council.
Yes,
For
yep, forgot to do that. Yep.
Commissioner David.
Commissioner
Yes.
Ashby. Oh, sorry.
Oh, I was going to skip myself. I'm all set for now. Thank you.
Okay,
Commissioner David.
Yes, Attorney Feinberg, I believe that you asserted that the burden was on the complainant to establish that there was an accommodation. Can you quote me the law on that, or maybe I can also ask Attorney Hirsch?
Yes. Well, there are two issues in this case that Kristen and I will discuss in terms of burden of proof. One is whose burden of proof it is to establish that the individual is a qualified individual and can perform the job with or without a reasonable accommodation. And then there's an issue in terms of whose burden it is to prove the direct threat or safety defense. On the first piece, with regard to whether an individual is qualified and able to perform the job with or without a reasonable accommodation, the law says that that burden is on the complainant, both to establish the person is qualified and if a reasonable accommodation is needed, that there is an effective, reasonable accommodation available to permit the person to perform the essential functions of the job. And fortunately, I get to cite one of my cases that I argued in front of this commission more than 20 years ago, which is Reed versus LePage Bakeries. And, I believe it's cited in my objection. It's the district court site, but it went up to the First Circuit, is 102 F sup 2nd 33. And I don't have the First Circuit Court of Appeals decision affirming the district court in front of me. But that's the case in the First Circuit that holds, that confirms it's the plaintiff's burden. On the direct threat, as a defense, it's arguably the employer's burden to establish the existence of a sufficient safety issue. There is some mixed law in terms of whether the safety issue is built into the qualifications itself and can be part of the first part of the analysis. And that's where the burden on that can get a little bit confusing. I think Kristen will argue that it's the respondent's burden on this piece. And for our purposes, we don't take issue with that because it's our position, we presented more than sufficient evidence to establish the existence of a direct threat, given that the case law, and I can cite to it, indicates that it's not just the frequency of the risk, but the seriousness of the harm that comes into play should there be a problem. And I would point to the EOC Schneider case to support that legal principle. And that site is in my papers.
Another question. I believe I heard you say in your presentation, and I'm not sure I saw it in the written argument you submitted, both of those prior horrendous accidents were joggers, were that same job?
Yes, they were both joggers.
They were, okay. And what do you say to the issue of whether or not a hearing needs to be described as a qualification in the job description?
what we put in the job description is that must be able to communicate with fellow team members. And the courts say that you have to look at what that essential function means based on the job function. And so the investigator would have been required to drill into, as we discussed at the Issues and Resolution Conference and in the papers, what the job entails and why communicating with team members means verbal communications and the ability to hear, particularly not only because they're shouting to each other in terms of the quality of the print as it's being produced, but most importantly, during an emergency. There would not be time to accommodate with an accommodation to stop and either get paper or get an interpreter or even use texting when someone's hand is being dragged into the press. That does require an immediate communication. And it is the complainant's burden to establish that there would have been an effective accommodation for that issue. It's absolutely their burden to establish the existence of an effective accommodation according to Reed versus LePage, and none was presented for that type of situation.
When does that burden operate? When does he have to indicate that he can provide or argue that there's an accommodation he can be given? When in the application process?
As part of the case or as part of the process itself? That burden is part of the court case.
Part of the court case, yeah,
Right.
okay. Right, it's not in the application part of the case. His
The courts don't
application.
really.
Right, just to
speak
be
that.
clear, Commissioner David, this is not, this part of the case at least is not a reasonable accommodation case.
Excuse me for the interruption. This is the
Oh,
interpreter.
I'm
Being that
sorry, Mary.
Okay, yeah, so if you can just identify who is speaking, because I can't necessarily see everyone. Thank you.
Sure. This is Barbara Archerhurst, Commission Counsel. And I just wanted to clarify, there's a lot of discussion about the burden of establishing whether there's a reasonable accommodation. This is not a case, this part of the case, we're not talking about whether there's a reasonable accommodation. We're talking about whether the individual is qualified for the position. And yes, accommodations might come into that analysis, but we didn't get as far as whether an accommodation is necessary to do the job in this case.
Thank you, that's helpful.
You're
And I
welcome.
would say that with all due respect to counsel, I disagree with that statement.
Commissioner Finberg, if we have a question, the commissioners will absolutely let you know.
Thank you, Amy.
Commissioner David, did you have anything else?
No, that's, thank you.
Commissioner Dewson.
Well, I'm still puzzling about the responsibility for the burden of providing at which stage in the process. It's basically the same question that my colleague just asked, and I was puzzling through the answer and I'm still not clear. I wonder if Ms. Hirsch would mind expanding a little.
I will give it a go. What complainant needs to establish is that they are a qualified individual with a disability. And a qualified individual with a disability is an individual who can perform the essential functions of the job with or without a reasonable accommodation.
And what I understand from the investigator's report, I think it's page 5, the investigator summarizes their analysis. And am I understanding correctly that right now, the way things are analyzed, that at some point the respondent had the opportunity or burden and did not meet that opportunity or burden? They didn't, for me, it's weaving in the individualized assessment to determine if safety measures could be set in place to allow the complainant to do the job. That, in this case, should have happened during the application process, or did I understand your prior answer to mean that that is something that would have happened after the hiring decision was made and they were preparing to figure out if there was a reasonable accommodation?
Well, and again, this case is different because the applicant was rejected straight out because he could not hear. So from my perspective, my reading of Alice's report, and I'm sure they'll correct me if I'm wrong, is that there was no attempt to figure out whether this particular individual was able to perform the essential functions of the job. So part of that comes with the individual assessment. That's where that falls in. The employer, again, what I believe Alice wrote is that the employer assumed that non-hearing people could not perform these essential functions, and therefore didn't inquire further with this applicant.
So essentially, it's a very surface decision that because I cannot hear or raise the appropriate alarm in an emergency circumstance because I cannot hear, which is what the respondent is saying, they didn't go any further in the hiring process. Well, okay. And
Correct.
Then Mr. Feinberg, if I may confirm what I understood you to be putting into this conversation, you have not asserted that there was an individual assessment done. Is that correct?
Commissioner, thank you for the question. Our position is that based on the information that was presented, which is that the complainant requires an ASL interpreter, that an interactive process would not have yielded any additional information. And the case law indicated in the paperwork indicates that an interactive process in and of itself is not required if it would have been futile. And the complainant nor his counsel have argued that that an interactive process would have yielded any information indicating that in this type of situation, he could have performed the essential function of the job.
Thank you. I have no further questions.
Commissioner O'Brien.
Oh, you are, there you go.
I'm all set. Thank you.
Okay, then now we will hear from counsel for complainant.
Thank you very much.
Can we just take a moment to switch interpreters?
Sorry,
All right, good time.
I'm going to unpin you and pin, where are you? There you are. Okay, pin you. How's that? Mr. Richards Cretlow, can you see the interpreter?
I found her. Yes, thank you.
Okay. Go ahead, Ms. Aiello.
Good morning. Thank you. My name is Kristen Aiello. I'm here for the complainant. There's been a lot of discussion about the burden of proof here, and I will say that under long-standing precedent from the Maine Law Court, Canadian Pacific, over 40 years of precedent, it is squarely the defendant's burden to prove that there is a safety concern or a safety risk. So where the defendant ran afoul of the law here is when they failed to conduct an individualized assessment to the extent that my client had a genuine concern, to the extent that they had a genuine concern that my client was a direct threat due to his deafness. Respondent was responsible under the Maine Human Rights Act to conduct an individualized assessment based on the best objective evidence to determine if there exists a significant risk of substantial harm to himself or others that cannot be eliminated by reasonable accommodation. Now that's kind of a mouthful, but it is absolutely unmistakable that it is the defendant's burden to prove that there was a direct threat in this case. They did not prove that. And what's really ironic is that the defendant is saying that my client didn't provide information about reasonable accommodation. Well, guess what? That's because he was completely shut down from day one. let's go back to what happened in this case. My client applied for the job, and I will say that he applied for the job. He got an interview. Respondent canceled Steve's interview 2 days after they made it, telling him that they filled the job, when in fact they did not fill the job until 14 days later with a less qualified candidate. I want to talk for a minute about my client. He's OSHA trained. He has 10 years of experience in the printing field. He has manufacturing experience, and he has a degree in occupational studies with a concentration in printing technology from Rochester Institute of Technology in Rochester, New York. He received a degree in this. He is very well aware of safety issues on a factory floor. As a person who is deaf, he takes that very responsibly. And I want to say that there's no question that there was a horrific accident that we heard about from Mr. Feinberg. They've been in operation for 100 years. It's not a surprise that there'd be accidents on the factory floor. But it would also be a tragedy to disqualify an entire class of qualified people like my client from working at Dingley Press. And that's exactly what they're saying. They're saying, if you can't hear, you can't work here. Let's take that apart for a second. People who are on the factory floor wear hearing protection. My client had a job developer. And again, here's more evidence that he was qualified. His job developer is a professional in matching people with jobs. He operates in Auburn. He's very well aware of Dingley Press. He was well aware of the job description for Dingley Press. He matched my client with Dingley Press as a great match. My client wanted to work there. He has a family to support. He has experience. He has 10 years of manufacturing experience. And yet what happened? He can't hear. So they're saying that he's done. He has no chance. We're not even gonna look further. Now I want to say that who got hired in place of my client, when they told my client that someone was hired, but someone really hadn't been hired for another 14 days, someone without manufacturing experience. Now that's listed as essential job function, but that was excused. Hearing is not listed as an essential job function. We've heard nothing from respondent about whether or not they do hearing tests for people, whether or not the hearing the hearing protection interferes with hearing. And I would submit to the commission, I'm no expert in this field, but I would think that if you're relying on people yelling out when they're injured, you have a problem on the factory floor. This underscores how they missed an opportunity to make this job accessible, not just for my client, but to improve it for everyone, because that's what universal accessibility does. And there were certainly, I shake my head when I hear the respondent say that my client didn't suggest any reasonable accommodations. It wasn't his burden, but guess what? He did. When he was turned away just summarily from the job, despite his incredible qualifications, he went to a job fair with his job developer. He talked to the person who actually turned him away. And he and his job developer talked to her about visual alarms, assisted listening systems, visible accommodations to communicate, installation of flashing alarms. What respondent failed to do was do an individualized assessment, which is absolutely required for them to prove that there was a direct threat. There is no question that they did no assessment except to say he asked for an accommodation for his job interview. That's ridiculous. They did no assessment whatsoever. They just simply said, my client, sorry, he's deaf. It doesn't matter that he has Rochester Institute of Technology gave him a degree in print technology. He's an individual who's deaf, who, like other people who are deaf who go there, get degrees in print technology. If he's not qualified to work in the industry, why would he get a job from a major respected university in the area? The bottom line here is that under Warren versus UPS, and that was a case that we represented the plaintiff in, Disability Rights Maine represented the plaintiffs in trial and on appeal to the First Circuit. That case affirmed Maine Human Rights Commission versus Canadian Pacific, which says an employer cannot deny an employee an equal opportunity to obtain gainful employment on the mere possibility that his physical handicap might endanger his or other health or safety at some indefinite time. I think it's unpersuasive to say that there were a couple of factory accidents. I'm not diminishing how tragic that was, but to say, therefore, an entire class of people with disabilities can't work at Dingley Press when they don't even include hearing as an essential job function is not persuasive, and the commission should not take the bait. The commissioner was absolutely on in her report. She analyzed the law correctly. She stressed that the respondent did not engage in an individualized assessment to determine if safety measures could be set in place to allow complainant to do the job. My client tried to raise that. They did raise that at the job fair, and again, summarily turned away. So there's no question that the investigator was correct. I want to say, obviously myself and Mr. Finberg represent our clients, right? It's our job to represent our clients. There's one person who is unbiased in this equation, and that was the investigator. The investigator conducted an investigation by looking directly at the affidavits, by asking for additional information, by looking at all filings provided by the parties, by interviewing the witnesses who had first hand knowledge of what happened. And the investigator did all that, made credibility determinations, cited the correct law, and made her recommendation. I urge the commission to follow the recommendation with one exception. And again, I represent my client, but I will say that I think there was one recommendation that I would take a second look at. The investigator indicated that my client was not discriminated against in the application process because the employer said that he could have an ASL interpreter for an interview. But what happened 2 days after they said he could have an interview, they emailed him and said, sorry, we're not going to have your interview. You're not qualified because you can't hear, you need to hear bells and whistles in the workplace. End of story. So he was, I would submit, discriminated against in the application process, as well as the respondent failed to hire him because of his disability. There's really no question in this case. It's not a close call. The burden was on the defendant. The defendant didn't do any kind of an individualized assessment that was required under the law, and therefore the investigator's report should be upheld. And I'll reserve the rest of my time to the extent there is any. Thank you.
Before you go on to questions, commissioners, I would just note that with all due respect to Ms. Aiello, the second proposed finding, there was no written submission contesting that. So I would just note that she's entitled to present in response to the respondent's written submission, but there was no written submission contesting the second proposed finding.
So Ms. Nearson, if we could change
Yes.
interpreters at this time.
Yes,
again?
sorry about that. And
That's
sorry
fine.
for not telling you who was speaking.
That's fine. Mhm.
Add pin. Okay, and remove pin. Okay, did I get it? Okay.
Just one moment. He's not indicating that he can see
Yep.
the interpreter speaking at this
Yep.
time, so just one moment.
Yep. Mary.
Oh. Okay, thank you. I'm good. And thank you, Ms. Nearson.
So I think next, Commissioner Ashby, you are going to inquire about questions.
I was. I'll waive questioning at this time and invite Commissioner David if he has any questions.
Yes, my first question was going to be exactly what Amy, what you commented on in that second finding. It seems to me, Attorney Aiello, that you're concentrating in your presentation on the fact that there was not an individual assessment, and that would seem to be discrimination in the conditions of the application process. And yet that's, the investigator finds there's no discrimination there, and Amy just tells us that there's no there's no rebuttal to that, and therefore that's not on the table as a challenged finding? What's the status of that? I was also going to ask Barbara, how did those two get separated? Aren't they the same? The discrimination is in failing to hire this applicant. Isn't it? Isn't that the complaint?
Are you asking me, Commissioner?
Yes, I'll ask you.
Yes, I think the main complaint is the failure to hire. I think as far as what the investigator was getting at was a more minor point, just in terms of discrimination in the application process. But the main point here is failure to hire. And having been practicing before the commission for 20 years, I have tried to object to in the past one of the findings, and it didn't make sense to the commission then. And so I just didn't, because it was not the primary finding. I think that the commissioners can certainly do whatever they want in terms of making their findings. But that's, I think that the primary argument here is that the respondent failed to hire my client because of disability and thereby discriminated against him.
In your presentation just now, you put bells and whistles in air quotes to us, and I don't understand that. Bells and whistles are OSHA requirements, and they're exactly relevant to hearing and to safety on the job floor.
Absolutely, and I don't diminish that in any way. I put in bell and air quotes because that's what was said, and because during the process, bells and whistles became safety alarms from counsel for respondent. So when it started out, it was bells and whistles in the process, and then it just progressively got more focused on safety, which is important. But the problem is that the respondent never even considered what measures would mitigate any safety risk that they perceive. Here, they just didn't do that. They're responsible to do that under the ADA and the Maine Human Rights Act, and they didn't.
Thank you.
Commissioner Doosan.
I have no questions.
Commissioner O'Brien.
You are muted, Commissioner O'Brien.
Yes.
There you go.
Thank you. This is, I think it's probably a really basic question, and I think it's for you, Kristen. Hello,
Okay.
by the way. In number 9, under the job description does not say that the employee must be hearing, because that would be a discriminatory statement. So just so that I can get my head straight, they cannot, are you saying that the individual assessment is that because it's not in the application, then it cannot be in the application? Is that correct? Is that correct?
It's not written as a essential job function. Is that what you're saying? That's what the
Yes.
employer says. That's correct. That's what they say. It's not included. It's not included there.
It's not included there. So then is the individual assessment where, how can I say that? Is that what you're saying? It should have gotten to that point, the individual assessment?
Yes, I think that in order for the defendant or the respondent to prove their case, that my client was a direct threat, they would have to conduct an individualized assessment based on objective evidence to determine whether or not there were reasonable accommodations, for example, to mitigate their concerns about safety. And they didn't do that. And we contest that there absolutely were reasonable accommodations that could have been taken, that my client and his job developer conveyed to respondent at the job fair, but they were brushed off. It was never even considered.
Oh, okay. I'm not sure if it's relevant to us. I'm not sure if it can be was talked about, but can you talk about what those accommodations were? Is that allowed at this point?
Well, I can talk about what was in the record and what was provided. What's in the record is options for reasonable accommodations that respondent could have considered were things like visual alarms, assistive listening devices, visible accommodations to communicate audible alarms and messages, installation of flashing lights on alarms and equipment. So you have things like even, even home alarms will have flashing lights. There are ways to accommodate people who are deaf in these circumstances. And they could have been employed on the factory floor. My client has a degree in print technology. He went to the RIT, a program for the deaf. It's a traditional field for the deaf. And so these things could have been even tried or considered, and none of that happened.
Thank you.
Thank you.
As I understand it, Amy, there are 10 seconds left for Mr.
So-
Finberg.
Respondent has 10 seconds, complainant has like 30 seconds.
What that would do for us, though, Mr. Finberg, is if you wish to be heard, if other commissioners have questions for you after, it'll be an opportunity to open up the floor for that. So you may want to take your 10 seconds.
Happy to defer and let Alice speak, or please.
Before we go on, Mr. Finberg, if you don't want to add anything, I guess we would ask commissioners if they had any follow-up questions for you after hearing from complainant.
Yes, I do. Attorney Finberg, what do you say to the claim that you had an obligation to do an individualized assessment?
As I noted in the papers, you don't have to do an individualized assessment when the evidence shows that it would have been futile. In terms of the reasonable accommodations, we have the lights, we have the mirrors, those are all in place. There is no reasonable accommodation that would have addressed the emergency situation that we've identified with the stuck hand and needing to communicate verbally and hearing that. And because an individualized assessment on that piece would have been futile, the employer was not obligated to engage in that process.
Thank you. What's up?
Are there any other questions for Attorney Finberg? Ms. Aiello, I believe you have now 30 seconds.
Thank you. I would just urge the commission to consider the investigator's recommendation. She made credibility decisions. She reviewed the evidence firsthand. She reviewed the affidavits firsthand. She applied the law correctly. This case is not, I think this case is not even close. The respondent failed to conduct that individualized assessment. And we have a client here, a man who is absolutely qualified to work in the field. He has 10 years of experience in
that's your
print.
time.
Thank you.
I have a question for Ms. Aiello. Is it your position under Canadian Pacific that an individualized assessment is required in every case in which this level of harm is alleged by an employer?
Canadian Pacific did establish that if an employer is indicating that someone is a safety risk and cannot be hired, for example, because they're a safety risk, then it's my recollection and reading of that case that an individualized assessment would be required before that decision is made. It says that the defense requires individualized assessment of the relationship between an employee or job applicant's physical disability and the specific legitimate requirements of the job. That's Higgins and Canadian Pacific.
Thank you.
Thank you.
Any other questions for Ms. Aiello?
Yes, Jeff. Attorney Aiello, you just said that credibility was at issue here. That's the one thing that I didn't see in this case anywhere was a challenge or an issue about anybody's credibility. Seems to me that we have legal issues about what goes in the application, whether the individual assessment is necessary and that kind of thing. Whose credibility is at stake?
Well, the investigator interviewed witnesses in this case. And so anytime witnesses are interviewed, there's credibility determinations that are made. So I'm just underscoring the fact that this was a pretty comprehensive investigation.
Any other questions? Thank you, Ms. Aiello. I think we hear from our investigator, Alice Neal, at this point.
Good morning, commissioners. I am
I'm
Alice
sorry,
Neal. I just want to check and see.
Wait, hold on.
The
Sorry,
interpreter's going to
Alice.
switch?
Yep.
Yep.
No, actually, Mr. Richards was saying, I think I heard that.
Oh.
Whatever that beep was.
Oh, okay. Sorry, Alice, go ahead.
No, it's okay. I was just checking to see if the interpreters needed to switch.
Nope, they don't.
Okay. I want to thank you all for, I know that we've heard a lot this morning from the parties, and I think the attorneys have fairly well laid out what the different issues are in the case from what they see from their client's perspective. There are a couple of things I just wanted to highlight for you all as part of your consideration of the case. And as Attorney Aiello mentioned as part of her presentation, the concerns about bells and whistles during the course of the investigation did progress from being just alarms to being more focused on emergency concerns or accidents, and those things were not necessarily primarily brought up throughout the investigation. I do want to point out for the commissioners also, and this is not to diminish the accidents that happened or the trauma that people have had at Dingley Press. However, something that the commissioner should know is that and I think that you probably realize this, and just to highlight it, is that the individuals who did have these injuries happen and the hand incident took place with people who are hearing. And, you know, they haven't had any incidents happen where they've had employees, because they presume that employees who are non-hearing can't work on the press floor. The respondents haven't presented any information about what could have been done or what is a possibility to deal with the emergency situations with someone who is non-hearing. So we don't have that information in the record. So, you know, I've heard what the parties have said in the presentations. I think they've addressed all of the facts. I'm happy to answer any questions, but none of my recommendations have changed from hearing the presentations today.
Thank you, Alice. Do folks have questions? I'll forego questioning. Commissioner David, do you have questions for our investigator?
Alice, why did you divide the two recommendations between hiring and application?
Because they're technically two different claims. In terms of someone being treated differently in terms of their being part of the application process is one part of a way that they could have a claim of discrimination, and whether or not they're actually hired is a second standalone claim. So I look at them separately.
And you stand by your second recommendation that there's no reasonable grounds that there was anything wrong in the application process?
I do certainly stand by that. But as Attorney Aiello pointed out, you as the commissioners have the ability to make your own findings.
Okay, well, that seems to me to focus our decision fairly narrowly on these issues of the place of hearing in the safety requirements of the job. Is that a fair statement, you think?
I think that the questions really do stand around the safety and the hearing and being able to perform the functions of the job.
Thank you.
Yes.
Commissioner Dewson.
I'm debating whether I wish to voice a question on the second recommendation. I guess I'll just ask a clarifying question of the investigator. The offer to have ASL interpretation during the interview was sufficient, and you were not, the fact that that the hiring decision was made before that interview with ASL interpretation happened did not change, or how did you assess that piece of it?
Well, so for me, I saw them as distinct pieces. In terms of the application process, complainant applied, and when he let them know that he needed an accommodation for the interview, they said, okay, sure, that's fine. And so to me, that was related to the interview and the application, but then it was respondent's summary decision just to not even go further because it made a decision that because he was non-hearing, he couldn't do the job. But to me, that was the failure to hire. So that's how I parsed those separately.
Okay, thank you.
Does that help?
Yes, very much. Thank you.
Okay.
And Commissioner O'Brien.
I'm all set. Thank you.
Okay.
Thank you, Alice.
That completes the presentation of this case, and I will entertain, unless Ms. Sneerson tells me otherwise, I'll entertain a motion or motions. We have 2 findings by the investigator.
You might want to consider taking them separately in case some commissioners want to address the second one in a way that's different than the recommendation.
Okay.
So I'm not suggesting should be done, but it sounds like from people's comments, like they may want to.
Thank you for that. Let's take them separately. As to the first findings that there are reasonable grounds, is there a motion?
Commissioner Doosan has her hand up.
All right, Commissioner Doosan.
I will move that the commission find that there are reasonable grounds to believe that Dingley Press discriminated against Stephen Richard Cretlow on the basis of disability when it failed to hire him, and that portion of the complaint should be conciliated.
Is there a second? I'll second that motion. Any discussion? Commissioner Doosan.
For me, this turns on my direct question, well, the documents and the record, and then my direct question to respondent to make sure I was understanding the documents. I asked if he was asserting, if respondent was asserting that an individualized assessment was conducted. And as I understood his response, while the accident cited are certainly horrible things that we would hope would not happen to anyone, and that we would hope an employer would put in provisions to prevent it from ever happening again. He offered these as support to the conclusion that a non-hearing person cannot do this job. Actually I'm hesitating because I'm not sure how much we should talk about this, but respondent came very close to asserting that no such assessment was necessary because it was almost a foregone conclusion. And the very point of the language in the Human Rights Act is that there be an individualized assessment, that this kind of decision not be made on a generalized basis, even when that generalized basis is really the terrible things that happened to 2 other employees who were hearing, by the way. So I believe that the assessment was required. I believe the law supports that. I believe the investigator's work supports that. There was no individualized assessment prior to the conclusion that this complainant could not do this job. And so I would support the reasonable grounds. If such an assessment had been done and then the employer concluded that the employee could not do the job, that's the whole point of the process. So, yeah, I'll stop talking.
Thank you, Commissioner. Any further discussion?
Yeah, I'm troubled. If I was told that an individualized assessment in this case, in this application, was a legal requirement, I would follow that. But it seems to me that it's not the case that they found that the fact that he was non-hearing meant that he couldn't do the job. It meant that he was a safety risk. The fact that those other incidents over the years are by hearing persons makes the concern even more poignant and direct, that you have to have that hearing. It does not it does not bother me that you don't put hearing, the words H-E-A-R-I-N-G in the application, that you say communication. I think that's trivial. But it seems to me that what they're saying is not that he can't work at Dingley Press, not that he doesn't have the qualifications and the technical ability to do design and engineering and all the other things. They're saying that the requirement for hearing is a safety concern on the press floor, and that doesn't seem to me in any way based on anything that's discriminatory, other than appropriately for safety concerns. So I'm going to vote against the motion.
Thank you, Commissioner. Any further discussion? Commissioner Doosan.
I just want to make a correction. Words really matter in these circumstances, and I thank Commissioner David for his comments. I spoke imprecisely. My intent is to be very clear that the individual assessment that I have in mind that is required is to determine if safety measures could be set in place to allow complainant to do the job.
Okay. And what I heard was that the safety measures that are there are bells, whistles, and lights, and the need for verbal communication, which is based on hearing. And that's what's missing in this particular jogger on the press floor. Thank you.
Any further discussion? All right, it's been moved and seconded that the motion is that there are reasonable grounds to believe that the respondent discriminated against the complainant on the basis of disability and that the complaint should be reconciled or conciliated, in accordance with the act. All in favor of the motion, raise your hand and say yes. Yes.
Yes.
See 1, 2 in favor.
All those opposed, raise your hand and say no.
No. And Commissioner O'Brien
No.
is yes, yeah.
No.
Commissioner O'Brien, you're a no also?
Yes.
That's 2 votes for the motion and 2 votes against. And when there's a tie, my understanding, Ms. Sneerson, is that the reasonable grounds finding remains in place and that the complaint.
Actually, under our current rules, when there's a tie, the default is a no reasonable grounds finding.
That's embarrassing. I'm so sorry. Please accept my apologies.
Okay,
Everyone.
it's okay.
That's a large mistake. I'm sorry about that. Okay. There is a second finding by the investigator that there are no reasonable grounds to believe there's been discrimination based in the conditions of application process. Do I have a motion for that finding?
Yeah, I'll move adoption of that finding that there's no reasonable grounds to believe there's discrimination in the application process.
All right, it's been moved that there are no reasonable grounds. Is there a second?
Second.
Commissioner O'Brien, correct?
Yes.
Thank you. Any discussion?
This is the interpreter. Are you able to hear me?
Yes.
Okay. Previous to the motions, I had spoken and asked for a pause to switch interpreters.
Oh, I'm sorry.
To address
so
the
sorry.
second one. But
Didn't hear that. Okay.
Okay, no problem. And in just a second. I'm not, Mr. Cretlow Richards is saying he's not yet able to find the interpreter. Okay, good now.
Okay, thank you.
Thank
So
you.
I think we had a motion and a second.
There's a motion and a second. Is there discussion? Hearing none. All in favor of the motion that there are no reasonable grounds to believe that the respondent discriminated against the complainant on the basis of disability by treating him differently in the conditions of the application process, and therefore the complaint must be dismissed. All in favor of the motion, raise your hand and say yes.
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 That's unanimous.
Yes. So both findings are no reasonable grounds, and the commission will send the parties a letter confirming that. And just so you know, Mr. Richards Cretlow, if you want to stay and continue watching the meeting, you're welcome to. We'll keep the interpreters as long as you would like. But if you are going to leave, just let us know so we can let them go. You don't have to say anything right now. You're finished. The hearing is finished now. Your hearing.
My hearing is done?
Yes. Yes. We're going to go on to other cases now.
Thank you so much, folks, for your help today.
All right, thank you. I guess in that case, I'll leave as well.
Thank you very much.
Thank you all for your consideration.
Thank you, Mr. Richards Cretlow.
Thank you.
Bye.
Thank you, counsel.
Thank you, counsel.
Okay, we are now taking up MHRC number E19-0140 A through G. That is complainant Marissa Ikasi. Forgive me if I've mispronounced that. Versus St. Mary's Regional Medical Center et al. This is reasonable grounds finding. Amy, how do you want to handle this? Do we have different counsel for each complaint or for each respondent?
No, there's one attorney for all the respondents.
That's helpful. Counsel for the respondent, are you here and ready to go?
Yes, this is David Strzok, counsel for the respondent.
Thank you. You have 10 minutes.
Thank you. I'd like to start by just thanking Commission Counsel. This is a highly unusual case, and Commission Counsel went to extraordinary efforts to try to find a path forward that did not involve a reasonable grounds finding. So many of us have a chance to thank her, so I'll do so. I also want to say that I'm far more expressive in my written correspondence than I am verbally. So I'm going to try to keep my comments short and rely on the written submissions, which admittedly were probably the most written submissions I've ever submitted to the Commission in 15 or so years. This case involves a complainant who's a physician at St. Mary's. The physician was involved in a medical review committee process at the hospital. And at the end of that process, she filed a complaint with the Commission alleging age, sex, race, national origin, ancestry, and disability discrimination. The filing of the complaint creates a very difficult situation for the respondents. The respondents are physicians and a hospital employee who were involved in the medical review committee process. And then the entities are the hospital itself and then the parent corporation of the hospital. Dr. Akasi filed the complaint against the respondents, alleging that the conduct that they engaged in as part of the medical review process was discriminatory in the multiple ways that she alleged. And this puts respondents in a very difficult position because there's another law out there called the Maine Health Security Act. And the Maine Health Security Act provides absolute immunity for those individuals who participate in the medical review committee process. It also provides confidentiality for the records associated with that process. And there's another statute out there. It's in the context of the medical board of medicine, which requires medical staff review information to be confidential as well. And so when we got the complaint, we submitted a letter to Director Sneerson saying, you know, we have these problems. There's an immunity and there's two confidentiality statutes. And it's a very unusual case because complainant provided substantial allegations, which on its face shows that the conduct that was allegedly discriminatory was part of the medical review committee. You know, most complaints don't have that level of detail where on the face of the complaint, you can see that this was part of the medical review process. And so based solely on the allegations in the complaint, we asked for dismissal, and that was denied. We then attempted to work with Commission Counsel to explain our position and figure out what we should do. The Commission Counsel wasn't inclined to change its normal process, so we ended up filing a lawsuit in the Maine Superior Court asking the court to issue a declaratory relief stating that the immunity provisions applied to the complaint and the confidentiality provisions applied. And essentially, with regard to the immunity provisions, one of your kind of guiding principles that I've heard many times is that the commission looks to determine whether or not there's at least an even chance of the complainant to be successful at a civil lawsuit. And if the immunity applies, which we think on the face of the complaint it provides it does, there can be no civil liability. And so there is impossible for the commission to find that there's an even chance, let alone any chance, that the complainant will be successful in a civil action. So we've asked the commission to dismiss the complaint. We don't think that this will come back. This is going to happen again because the Superior Court action is still pending. And we think that the Superior Court action will provide a significant amount of clarity to both the commission and the parties about what happens in the future. But with regard to this complaint, the respondents are in an impossible position. We can't provide the information because of the confidentiality, and we believe that the respondents are immune because of the immunity. I think the papers in substantial detail provide the analysis. I don't think I'm going to go through the analysis, but I will pause here to ask if there's any questions, or actually let the chair ask if there's any questions.
Thank you, Counsel. First, I have to ask, Amy, my format has changed a bit. Is that intended?
No, I'm not sure. All of a sudden, people were showing up as spotlighted on mine too. So if you go up, you can, I think in the top left-hand corner of your screen, you can remove spotlight.
Okay, I'll work on that in a moment. But all right, in any event, Commissioner David, do you have questions for Counsel?
Excuse me. Attorney Struck, you just said something about the significance of the fact that the complaint on its face revealed that it was dealing with the review process. Would there have been some other way to make a complaint generally about the hospital discriminating against me without referencing the review process? And would we be in a different universe were that the case? You still wouldn't be providing the materials, would you?
Well, correct. We would have objected to providing the materials, but the challenge would have been whether or not the commission sought to investigate the immunity issue first. In other words, the applicability of the Health Security Act. Typically, and what I recommended was, in this type of case, the commission should first determine whether or not the Health Security Act applies, and then if it does, take whatever course, take the proper course of action. Here, we didn't have to go through that initial process because the complaint on its face established the applicability of the Maine Health Security Act. So when I said it's an unusual case, it's because we didn't have to engage in any additional discovery to confirm that the Maine Health Security Act was in play.
And I'm going to ask this question also of Commission Counsel, but it just seems to me that when I read this, that there ought to be a way to duck, to wait for the Superior Court action to finish. So I guess the specific question is, from your point of view, do you believe it's possible to enter into a waiver of the statute of limitations of 2 years if the commission was willing to do that? In other words, as I read it, and I'll ask Amy and Barbara, but they're saying that we're forced to issue a decision because of our own 2-year statute of limitations that we have to make a decision. And since you guys didn't respond, the decision goes against you. Would you enter into a waiver of the statute of limitations? Is that possible?
Thank you for your question. I don't have authority. It wasn't raised to enter into a waiver, so it's a little difficult to put me in that situation. I think, and that's why I started off with thanking Commission Counsel, because we went round and round trying to figure out if there was a method under the statute that the investigator could, or the executive director could do something other than present a recommended finding. And it doesn't appear under the statute that the investigator or the executive director can do anything but present this issue to the commission for the commission to decide. So I think we did exhaust all avenues, but we did not discuss waivers. So, and I just wanted to take one issue with something you said, that we didn't respond. I would argue we did respond, and we did provide a response that said that the immunity provision applies, the confidentiality applies. And so I would argue that based on our response, the commission should find that there's no reasonable grounds because the immunity applies. If the immunity applies, there can be no chance of success for the complainant at a civil action.
Gotcha. Yes, you certainly responded. Thank you.
And Ed, in case you're still waiting for my opinion, it wouldn't matter if David wanted to enter into a waiver, because it's my opinion and has been the long-standing position of both me and previous commission councils that 2-year statute of limitations is not able to be told.
Is it possible for the commission, for the commissioners at this stage, having received this report and this recommendation, to table it? For a number of months until the Superior Court acts is the parenthetical.
Well, you don't table it for any specific period of time.
I understand that. I understand.
I don't see any reason you couldn't table it. I also don't see necessarily any reason to table it. My fair assessment, and David Strzok will jump in if I am wrong, is that the losing party is almost certain to appeal this decision. So we're talking about tabling for a very long time and holding up a case of discrimination, when in reality, and this was a large part of our briefs, what we recommend here is inadmissible and unenforceable. And I don't, while I hate to say that stuff publicly, in the end, I think that the underlying case should be allowed to move forward regardless of the legal issue here. We have cases all the time in which parties refuse to give us information. I understand in this case, Attorney Strzok is not saying he's refusing, he's saying he can't. And we've been arguing about the difference for a long time. But we have cases in which respondents do not provide information, and in which there are settlement agreements or other issues raising the possibility that there could be no recovery in a lawsuit, and we decide those all the time.
Thank you.
Thank you, Commissioner. Commissioner Dusson.
I am all good for now. Thank you. I have no questions at the moment.
Thank you, Commissioner. Commissioner O'Brien.
I'm all set. Thank you.
Okay, let's hear now, unless I'm wrong, from counsel for complainant.
Jeff, no questions from you. I look forward to your legal acumen, no?
Look, I'm just barely able to hang on today as the chair. No, I'm kidding. I would have, and I will ask questions, but I didn't have any questions in this case. Thank you.
So to Mr. Webert.
Thank you. Good morning. David Webert. I'm with the law firm of Johnson, Webert and Garvin, and I'm here with my colleague, Braden Beard. So I think this impossible situation is actually quite easy to work through. Federal law makes it very clear, unequivocally clear, and St. Mary's has never disputed this, that our important anti-discrimination and employment laws are a complete exception to any value or legal interest in peer review. Otherwise, you create a pretty big monster. We have a long history of race discrimination, sex discrimination, all kinds of discrimination in our healthcare facilities. And unfortunately, St. Mary's, you just recently found against them for a wall of shame in which they totally refused to cooperate with your proceedings. So federal law is very clear, and the Maine Human Rights Commission is entrusted by a work sharing agreement because it has the confidence of the EEOC to investigate federal claims. So and the only reason that state court case is still going is because St. Mary's strategically chose not to have me in it. So they did not include an essential party. So it's a sham case with no due process because obviously Dr. Akasi is an essential party. I asked to try to get in the case. They don't want me in the case, which makes the case a nullity. It's not going to have any binding effect whatsoever. So it's a fake case. The other thing is I amended the complaint to make it clear that there is conduct besides the peer review activity, and also that there are exceptions to immunity that are on the face of the complaint. So the face of the First Amendment complaint makes it clear that peer review does not apply, both because there's sex discrimination that occurred after the peer review process, and also because they didn't follow their own procedures, and Maine law says you have to follow your own procedures to get the benefit of the immunity, which makes sense. And they blatantly violated the procedures. So this whole immunity thing is a bit of a sham because they don't want you to know, they don't have a defense on the merits. And the reason I say that is their own internal review has been very helpful to Dr. Akasi. It has vindicated her twice. So there was an initial review which found that she had been unfairly singled out for discipline when other people had done worse things, and threw the whole thing out. And then this time around, the head of the medical committee misstated it and said that she had been found guilty before and provided this stuff without mentioning there had actually been a hearing and a decision that she had been singled out for discrimination. So I can see why they don't want to provide their internal reviews, because their internal reviews completely are on Dr. Akasi's side. So in this second process, they sent her to a doctor. They chose the doctor, and the doctor completely vindicated her, said she's considered one of the best surgeons there. She gets along great with everybody, no need for any limitations. And then their own committee that they had to investigate it looked at it and said, we see no reason, no disruption, no problem. And then the head of this committee, who is named, and the committee sat on that for months and with no basis found that she was disruptive and made that finding against her in the face of their own doctor and their own ad hoc committee. So this is not an even chance case. This is an overwhelming case, and they darn well know in federal court, there's no privilege for this immunity. This is all bogus. It's all going to go away. So this is a fake ruse by St. Mary's to avoid responsibility when they know their own documents show discrimination. Dr. Akasi is one of the best surgeons they have. It's in the file. And this whole thing of disruption is ridiculous. They have, her one weakness is she does not like to not provide top quality care to her patients. And so when they're implementing a new record system that doesn't work correctly and it's jeopardizing patient care, she expresses her, unhappiness with that rather clearly. And that's the kind of surgeon I want when I go in for surgery. And that's why their own doctor who looked at it and their own independent ad hoc committee said she's devoted to patient care. She gets along fine with people, and there is no basis for any kind of discipline. And in the face of all that internal review, they blew off their own peer review process. They showed no respect for their own peer review process. So it's a little hard to listen to all this hiding behind peer review process, because their own peer review process strongly supports Dr. Akasi's claim of discrimination. So I'd like to reserve the rest of my time unless there are questions now. Thank you.
Thank you, Counselor.
Commissioner Ashby, I'm sorry to interrupt you. Before we go to questions, two things I would just let folks know. Mr. Weber's reference to a prior case that the commission had regarding St. Mary's is not part of the record in this case. So I would advise that that's really not something you should be considering. And second, there was a reference to the commission enforcing the EEOC, the laws that the EEOC enforces. We do have a partnership agreement with the EEOC. We do not enforce federal law. We enforce the substantial equivalent of federal law. That's what our partnership agreement stands for. I just would like to be very clear anytime someone says that we're enforcing federal law. So thank you.
Thank you, Amy. I'm going to, again, hold off on questioning, but does anyone have questions for Attorney Weber? Commissioner David.
I'm confused about the reference to a federal case. Is there a federal case too now? A federal lawsuit?
You usually bring your federal and state claims together, which is when your general counsel makes an excellent point that this stonewalling by St. Mary's is holding up the case. You're not supposed to bring two separate cases. So we would be on the verge of bringing a consolidated federal and state law.
What are you referring to as a sham case? Their case in Superior Court saying they can't
Exactly.
cooperate?
Because
Okay.
Dr. Rossi is an essential party. They didn't name her. It's a violation of due process to be seeking remedies against her and not naming her as a party. And they know it. It'll never hold up in due process. They just didn't want our effective advocacy in the case, as far as we can make arguments that the Maine Human Rights Commission can't. Like the executive director is just explaining, we can point out this federal side of things, which is an open and shut reason why this doesn't make any sense. We're going to go to court. We're going to get all this stuff, and they know it. And the reason they don't want to put it out is it's bad for them. Their peer review totally vindicated Dr. Akasi.
But I'm confused. The peer review, you've said several times, totally vindicates her, and yet this is what is this group? Aren't they a peer review? Isn't that who's disciplined her?
The investigation, as I try to explain, and the complaint goes through all this, is that they sent it to their own independent doctor to do an exam.
We don't see the complaint, I don't think.
Well, the complaint on its face, you're saying that the complaint on its face, it has all these details in it. So they sent her to a doctor who said she's fine. She's an excellent surgeon. She gets along with people. There's no limitations. There's no basis for any concern about her being.
Oh, okay. So it is this group that you say sent her to an independent doctor to review an allegation of disability or incompetence or something.
Yeah. And then they submitted it to an ad hoc committee, which is part of their own rules. And that ad hoc committee totally found for her. So their own doctor and their own ad hoc committee. And then it comes back to these people that are at the top of the chain. And they say, we don't care what the facts are. We're gonna find her disruptive. So their own review process, the factual findings are on our side. It's just this decision that is totally contrary to all the evidence in their own peer review file that is against her. So it's a sham proceeding, and it violates their own procedures. Like their own procedures required that she be given a copy of the complaints against her and a hearing, and they denied her both. So the Maine law actually says, it's got to be according to procedures. You can't, you can call anything what you want. So they didn't follow their own procedures. Therefore, there is no immunity under state law as well.
Do we see what the discipline was, or does it not matter if there was any discipline?
Yes, it's in the complaint. It was a finding that she was disruptive, and she had to take a class for disruptive physicians to deal with that kind of behavior.
Okay. Yeah, now I recall that. Yeah.
Yeah, there was a finding that she was disruptive, which doesn't do you much good when you're looking for another job, or it's quite a millstone for somebody at her age who already has to deal with age discrimination and sex discrimination, but to stick that on her. And so it totally destroyed her ability to, she was thinking of moving to California, where her daughter is a great surgeon. She could be with her grandchildren. She can't move now because of this.
Is this on the record, Mr. Weber?
Well, I'm trying to answer the questions.
If you could answer it within the confines of the record, that would be great.
I believe it is in the complaint that we put those facts. Yes.
Great.
Thank you.
It is in the complaint that this totally stigmatized her and made it hard for her to find work.
All set.
Yep.
Commissioner Doosan.
I have no questions.
Thank you, Commissioner. Commissioner O'Brien.
Yes, I apologize to everyone if I think this is an elementary question, but her complaint is that she was discriminated against on age, sex, race, national origin, ancestry, and disability. And how is that? How is it proven that she was discriminated for all of those things? Again, I apologize if it's a very basic question, but I don't see where that shows that.
Is that a question for me?
Yes.
Okay, well, the complaint has a lot of details about this, but there's the violation of their own procedures and the fact that they ignored their own doctor and their own ad hoc committee is evidence of pretext. In other words, that this disruption thing is a false reason.
Okay.
And that is evidence in any court of law of unlawful discrimination. And unfortunately, she hits the jackpot with strikes against her. So she's a female surgeon. It's amazing she became a surgeon, given the odds for female surgeons at her age. That's amazing. And age discrimination is very apparent. She's got an accent. So she's not from Maine immediately. She's got a foreign accent. So all of this, the stereotypes are that you're disruptive and that you're a problem. And so there's lots of social science. And I did cite all this because I'm trying to stay on Amy's good side. And by the way, complaint allegation 39 goes into how this adversely affected her job search. Although I would like to clarify, sometimes I try to talk about things that I think are legislative facts, which inform your sense of how the world works and how things are plausible or not plausible. And in courts, those do not have to be in the record. But if I stray into those, it's my habit from being in court where that's allowed, but I'm trying not to violate anybody's rules. But anyway, so I try to put all this in the complaint. So there's lots of social science, but the fact that she's one of their best surgeons and they keep trying to get rid of her, and their own factual review process to say, there's no reason to get rid of her, she's one of your best surgeons, that's evidence of age discrimination, sex discrimination, and against her for being a foreigner. The disability discrimination is on the face of the complaint, is that they sent her for this review because she had double vision, which was bizarre because it was from a car accident 30 years earlier. She's been a great surgeon for 30 years, and they used that, and they didn't even send her to an eye doctor. They sent her to a psychologist. So that is such a sham on its face, and they never even followed up on that. So that's just an obvious, they gave it as a reason. And being required when you're a surgeon to go to a medical exam to prove fitness is a killer. I mean, it's so stigmatizing for everybody that you have to go get a medical exam. So the fact they did that for double vision that she had from a car accident 30 years older, which didn't affect her ability to perform surgery at all, is the evidence of disability discrimination. So we didn't get into the merits because from the very beginning, St. Mary's stonewalled and wouldn't respond, but there's plenty of evidence. My complaint is very detailed and it covers all those bases.
Thank you.
Sure.
So just so we know, and sorry, Commissioner Ashby, when you get to it, respondent, Mr. Strzok has 4 minutes. Mr. Webert has about 5 minutes left.
Great, thank you. I was going to say that I believe Mr. Strzok has some time. So, Mr. Strzok.
Sure. I'd just like to ask that the executive director step in quicker when attorneys try to sling mud about referencing other decisions. That was beyond inappropriate, and it just I just ask that try to keep that out in the future. Second point, he made just demonstratively incorrect statements. One, we did not want him in the Superior Court action, or Dr. Akasi. It's not accurate at all. It's not our job to invite him into the action. It's his job to seek intervention, and he didn't do it. And to my knowledge, he never filed anything in that action. Second, he made the statement, we're trying to get rid of Dr. Akasi. There's nothing in the record that we were trying to get rid of her. This was a peer review committee process, which in general tries to make the best physicians possible, and that's what was going on. Third, he said that we didn't even name Dr. Akasi in the Superior Court action. I'd ask that you ask commission counsel about that if necessary. We were told we could not do that. We signed a confidentiality provision when we received the complaint, and we take that seriously. And so we went to great lengths not to identify Dr. Acosta in the court action. Third, he talked about stigmatizing and how that can stigmatize a physician if people learn that she's sent to some sort of medical examination. That's the whole point of the confidentiality. That's why the confidentiality exists. We can't bring that forward for exactly that reason. And lastly, I think Attorney Weber made your job a lot easier, because in response to Commissioner David's question about the medical review process, he admitted without any question that the individuals that are named as respondents and the conduct at issue here was part of a peer review process or a medical review process. If that's the case, the legislator made a very clear decision. They get absolute immunity, period. And the Maine legislature made that decision. We ask that you follow it, and we ask that you issue a no reasonable grounds finding in this case.
Thank you, counsel. I have a question. I thought I heard you say in your initial statements, and I definitely heard Attorney Weber say that the complaint alleges conduct that was in part arising out of the professional review committee process. Is it the case that some portion of facts complained of fall outside of the professional review committee process?
You're asking me?
Yes.
Sure. Our reading of the complaint was that the allegations that were allegedly discriminatory all arose out of the medical review committee process. They may have been as a result of that process, but it was all part and parcel of that process.
Okay, thank you. Commissioner David.
Thank you, Jeff. No, nothing further.
Commissioner Dusson.
Is an appropriate time for me to double check what I understand to be the position of the recommended by Corporation Counsel. I just want to make sure I understand the two footnotes regarding the immunity claim. Is that okay? Can I ask Barbara a question, or do I wait until another point in this discussion?
By all means, ask
Okay.
ask Barbara.
All right. I wanted to ask at an appropriate time when the parties' counsel might have, if they strongly disagree, they'd have an opportunity to say something. Barbara, I'm looking at your footnotes, or the footnotes in the investigator's report on page 2, which go to the argument of immunity or confidentiality from the respondent's counsel. And am I correct in understanding that the read on behalf of the commission on this issue is that the immunity from civil liability does not apply?
Right. Immunity, this process that we are involved in does not impose civil liability or any liability of any sort, no matter how much I wish it did. So yes, it is my position that because apart from all the other arguments that have been made, that because this process does not result in any civil liability or change the parties' relationships to each other in any way with regard to civil liability, that the immunity, which I don't believe is absolute, does not apply here.
Okay, and as to the second footnote there, the respondent elected, which is perfectly within their purview to decide on their strategy in this matter. They elected to pursue the immunity and confidentiality issues around professional review and did not submit defensive information to the commission as part of the investigator's process. Thus, they didn't mount a defense, and thus the commission is left to, or the investigator is left to proceed based on the information that the complainant submitted.
That's correct. So the way this works, and this is partly just an over explanation, but so because on the face of the complaint, we believed that complainant had established her prima facie case, the burden then shifts to respondent to provide a legitimate non-discriminatory reason for its actions. Because they believed they were immune, they provided nothing other than we're immune. And therefore there was no legitimate non-discriminatory reason. So the process stops there.
Okay. Thank you. I just wanted to make sure I wasn't misreading.
Thank you, Commissioner. Do you have further questions for Attorney Straught?
I do not.
Commissioner O'Brien.
I actually don't see Commissioner O'Brien on here anymore. I think she may have dropped off.
She warned us that she may
did.
have spotty connection.
Yep.
What are people's thoughts about waiting a moment? I'd like to not proceed without her or vote without her.
I would say that it has been actually a good throughout most of this case that she has dropped off. So I would not necessarily recommend waiting because she's also missed a goodly amount of the arguments. So I would question whether she should vote on the case since she missed some of the arguments anyway.
I have another question, Jeff. And I agree if that we need to go ahead without her if she can't make the connection. But I just wanted to ask Barbara, I mean, I struggle with this issue of what we're doing on a broad level when we make a finding, whether it has any effect or not. And we're told that it doesn't create any civil liability. And yet when we make a finding, cases go to conciliation, and conciliation attempts to I don't want to say extort as a pejorative word, but conciliation often is saying, well, the remedy here needs to be partly public recognition and partly money on some occasions. So I struggle with whether we're really doing nothing in terms of civil liability or not. I mean, if this case goes to conciliation, if we make the finding and it goes to conciliation, the same defenses are put forward by the hospital, and no, we're not paying her a dime, at least in terms of the money part. And they would certainly then say also any recognition or letter in her file one way or another or whatever is a civil remedy, right?
We can't impose any of that.
Right.
We can certainly invite the parties to conciliate. I do not expect that this would be a case where conciliation attempts would be accepted, let alone effective or result in a settlement, given the parties' positions.
Right.
All I'm saying is we cannot make them.
Right. Okay. And so we can't make them, and therefore we're not creating civil liability. That decision for conciliation, that's made by you and Amy?
No, if there's a reasonable grounds finding, the parties are offered the chance to use our conciliation.
They're offered.
We are required under the Maine Human Rights Act to invite the parties.
Thank you.
The statute requires us to do that.
Thank you.
The parties decline routinely.
Right. Oh, okay. Yeah. Okay.
And just, I feel compelled to say that I don't view conciliation as extortion. I'm sorry. We're required to participate in.
I use loaded words here for effect, and I shouldn't.
Follow up. I'm going to ask counsel for the commission. You don't, as I understand the footnote and your argument in the summary, in the response to the motion for summary judgment, you don't concede that there's immunity in every case in which civil liabilities at issue in any event, correct? I mean, I think
I do not.
You seem to argue public policy arguments in favor of disclosure of confidential information in these circumstances, under certain circumstances, as does counsel for complainant, as I understand it. Is that correct?
That is correct.
Thank you. Any further questions? Let's see. Do we,
We're
Commissioner
still
O'Brien?
on Mr. Strzok. We're still on questions for Mr. Strzok.
That's correct. Commissioner O'Brien, are you back with us?
Someone did just join by phone.
I think I'm back with you. Yeah.
Great, you are back
Not-
with us. We
Just on the phone, and I've missed a lot, so I have no questions at this point.
all right. We'll in a minute we'll visit the issue of whether or not you feel it's appropriate for you to vote on the case in light of the fact that you missed some argument.
Okay.
Okay. Any further questions by any commissioner for Attorney Strzok? I believe that Counsel Weber has, for counsel for complainant, has 5 minutes. Is that correct?
5 minutes. Yep.
So I'd like to go right back to a very important question that Commissioner Ashby asked, which is following up on my point that we're kind of arguing about nothing here, in that the complaint, the amended complaint, has allegations about discrimination that has nothing to do with the peer review process. And that's in the amended complaint on page 14, paragraphs 48 on. And it's about a situation that had nothing to do with peer review. A surgeon left that did breast surgery, and they dumped all the work on one of the 3 general surgeons without any additional pay. Guess who it was? The only woman, and my client. So she was treated like she's a really good surgeon, so they gave her the work. They didn't tell her it was happening. They just told the patients, and she was given no compensation or notice about that. So that's in the complaint. I think St. Mary's knows that's not peer review, and actually says in the complaint, these acts of discrimination beginning in October 2019 were not taken under the auspices of any alleged professional committee review or action. So on its face, the First Amendment complaint clearly alleges something outside the peer review process. And the fact that they're putting their head in the sand, ignoring that, just goes to show this whole thing is just stonewalling you and trying to keep this case from moving ahead. So, and then the complaint also explained, the amended complaint, how there's not absolute immunity for a bunch of reasons, one of which is one of the respondents is not a professional healthcare person. And even St. Mary's admits that they don't have absolute immunity. So that ends this whole thing as well, because one respondent is all you need for the Maine Rights Commission to have an ability to investigate. So, and we amended our complaint to say she acted with malice. So on its face, the complaint alleges all the claims against that person. I'm not going to name her, but she's a named respondent, so I probably can. But anyway, there's many reasons why that complaint in Superior Court is frivolous. And by the way, you can't violate due process by blaming the person you didn't name. So it's going to be a violation of due process for that case to have any effect when you don't have Dr. Akasi. And they could have added her as a Jane Doe. I've done that many a times. I think lawyers know how to do that. So she could have been named as a party without outing her. There's ways to do that. So that's not an excuse for not including her in the case. So this whole immunity thing it doesn't hold up. And as I said, federal law completely says it doesn't apply explicitly, clearly. So I know Maine is part of the United States of America. St. Mary's is part of a national health chain. They know federal law provides no immunity for peer review. So they know they can't cover this stuff up. This is a game they're playing because they don't like what their own peer review process shows. And I would say on this mudslinging charge, just so you know, in court, other acts of discrimination by the employer are highly relevant, come into evidence all the time. So when I'm in federal court with Judge Hornby or whatever, it's not mudslinging, it's admissible evidence. So I just want to clarify that. That's what that is. It's highly relevant evidence about their pattern and practice of how they treat the employment discrimination laws. Thank you. I'm all set unless you have questions.
Oh, you're muted, Commissioner Ashby.
I'm so sorry. Thank you, Attorney Weber. Commissioner David, any questions for Attorney Weber?
No, thank you.
Commissioner Dusson.
I have no questions. Thank you.
Commissioner O'Brien, we'll give you a shot and then we'll discuss again whether you'll vote on this.
Nope, you muted yourself. You were unmuted, then you muted. There you go.
Okay. Can you hear me?
Yes.
I really apologize about this. I'm very frustrated. I have no questions at this point. I have no questions.
Thank you very much. And I have no questions for Attorney Weber. At this time, we'll hear our investigator is our executive director. Is that
That's
correct?
the thing. There is, we had assigned an investigator to the case back when we were hoping to get information to actually investigate from the respondent. But when we realized that there was not going to be an opportunity to do that, we took the investigator off it, moved on, and we just have the report, which summarizes procedurally where we're at. So there, I think you guys, I believe you folks have asked all the questions, but if you have additional questions, I think either Barbara or I are the ones who can answer where we're at.
Thank you. I do interpret that as a sort of representation of what the legal issues presented are. And I don't have any questions of you, but if others do, or if counsel for the commission wants to speak up on issues that we may have missed, I'll invite that. Let's go in order. Commissioner David, any questions directed at either?
No, I expressed my queries about whether there was a way to duck, and both Attorney Struck and Commission Counsel have both reinforced each other's opinions that they tried as hard as they could, and we need to make a decision.
Commissioner Doosan.
I'm all set. Thank you, Mr. Chair.
Commissioner O'Brien.
All set.
All right. Well, I don't think I want to hazard an opinion as to whether Commissioner O'Brien ought to vote on this. It's really, I'm going to defer to Commissioner O'Brien. It's uniquely postured in that it's largely a legal case. Certainly it's been, the legal issues have been presented in the submission by our executive director, and then the written submission of the respondent. I certainly don't feel that she's prohibited. Commissioner O'Brien, I don't feel you're prohibited from voting. What is your pleasure?
Well, I would like to, I think I would like to hear from Commission Counsel on this, because first I feel uncomfortable making a decision. Is there
we have a quorum without
precedent?
you. We have a quorum without you, and certainly I have had to leave meetings in the middle of, well, I guess before cases are presented, but I've had to leave meetings and my vote wasn't counted.
Okay. Well, if that's the case, then I should recuse myself.
That's thank you for that, and that's certainly appropriate. We do have a quorum, so I think at this time I will entertain a motion. There are, I'm double checking, there are two, if I remember correctly, findings. The first, that there are, I'll take them, I guess we'll take them separately, that there are reasonable grounds to believe that the respondents discriminated against the complainant on the basis of age, sex, race, national origin, ancestry, and disability. And that conciliation ought to be undertaken under the Act. Is there a motion?
Yes, I'll move adoption of both 1 and 2 and 3, that there are reasonable grounds both to believe there was unlawful discrimination and there was retaliation in violation of the WPA, and the conciliation should be attempted.
Great, thank you. That
Second.
simplifies things, Commissioner David. A second by Commissioner Doosan.
Yes.
Any discussion? Commissioner Doosan.
I guess when I get to the bottom line on this very, very, very interesting and intricate case, and I appreciated the very detailed documents submitted by both parties. I just, if the final point of the commissioner's findings are based around there being a less than even chance that the complainant could be successful, I don't see how we can conclude that there's a less than even chance, given the absence of information from the defense, from the respondent in the record based on their claim of immunity and confidentiality. So she's made her prima facie, and I think I don't see an alternative to approving the reasonable grounds findings.
I certainly agree, Commissioner Dusson, that the complaint is the prima facie evidence, and that's there, and that's what we've got.
Okay, any further discussion? Hearing none.
I would just mention, because I can't help myself, that it's at least an even chance.
Oh, I'm sorry. Yes, sorry. Words matter.
Okay, then we are taking both all three findings together. All in favor of the motion, raise your hand and say yes.
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 Yes, that's three votes for yes.
Commissioner, and then Commissioner O'Brien is recused. Is that correct? So 3 in favor, none opposed, 1 recused.
That's my understanding.
Okay. Okay, so both findings are reasonable grounds, and the commission will send a letter to the parties in council confirming that.
Thank you, council. We are halfway through our cases to be heard. We could proceed to the third of 4 cases, or is there an interest in taking a brief break? I hear counsel for the commission saying, yes, we'll take 5 minutes.
Yeah, I would like a 5. Yeah, thank you.
10:47.
She and I can fight it out in the bathroom then. Commissioner O'Brien, if you're still on there.
Yes, I am.
Yeah, is the iPad working okay? I just want to check that.
Yes.
Okay.
No, the iPad's working okay.
Okay, just wanted to check.
Yeah. Well, the internet is not. I can read the information, but I can't get on Zoom on the iPad.
Okay.
Our whole internet is it keeps going off and on.
Oh,
So
okay.
it may pop back in, but I may not.
Okay.
So Amy, the prompt told me to *6 if I wanted to unmute. So do you mute me?
I can mute people, but I can't unmute them.
Okay, I can unmute. It told me how to unmute.
Okay. So I'll mute you?
Yes.
Okay. And then when
Yes.
it's time, you'll unmute yourself.
Correct. Yes.
All right. Deal.
Thank you.
Okay. Do we have everyone that we need back? I see Commissioner Dusson, Commissioner David, Commissioner O'Brien. I just heard we have counsel for the commission and our executive director. I'm assuming we'll find out in a moment if we don't have counsel for respondent and complainant, but let's turn our attention now to.
I see them both.
Great, perfect. Case number ED/PA 19-0375A. This is Tom O'Donnell versus Crab Apple Whitewater. This is a reasonable grounds case, and so we are going to hear from counsel for, or if there's no counsel, we're going to hear from respondent.
Hello, Kristen Collins for the respondent.
All right.
You can hear me okay?
I can, Attorney Collins. Thank you. You have 10 minutes.
Thank you. So my client is a very small family-operated company. They're a rafting outfitter on the Kennebec River. And this case involves an 8th grade school trip. Using this outfitter, the school has been doing this trip for decades as a sort of end of the year celebration for the 8th grade class. And, in working with the school has certain expectations about, the school being responsible for pulling the trip together, finding out if there are any special issues that need to be considered and communicating them to the company. There's on average 1 rafting fatality per year in Maine. While it's a fun activity, it can be an extremely dangerous activity. Anyone who's been whitewater rafting knows that it can get hectic and frantic, especially at the beginning of the summer up on the Kennebec when the water is high, things move fast. This particular trip has some challenging components in that for a large portion of it, about half of it really, it is completely cut off and that you're sort of in a chute with no access to any sort of rescue except for to stay on shore and wait for people to hike in to get you. So this case obviously is about whether the outfitter made a reasonable determination that it would be safe or that it would be unsafe in this case for this particular student to attend. Now, the first question here is whether Crabapple actually even prevented this student from attending. So the investigator references one of the employees of Crabapple as having emailed to the parents that our decision was made based on information provided from the school. I want to be clear that decision in the eyes of Crabapple was related to a decision about whether it would be safe or unsafe for the student to attend. They never felt like they were deciding that the student would be prevented from attending. They thought that that was a decision that was up to the school, being in charge of the student and in charge of his IEP. So the next question really is whether Crabapple, made a reasonable determination of whether it would be unsafe for this student to attend. And this was very much an evolving situation and a fast-moving situation over a 2-day period. So the school had been planning this trip since September, and Crabapple did not find out that there would be a potential issue with this one student until 2 days before the trip, actually the afternoon of the second day before the trip. And it is getting its information directly from the school through the teacher who books the trip every year, who attends the trip every year, and in this case happens to be the teacher of the student in question. So I've cited in our written materials the case of Fitzpatrick versus Falmouth. And what it says is, and first of all, just to reference the state law, what the Human Rights Act says is that it does not require an entity to permit an individual to participate in an activity when it will pose a direct threat to the health or safety of others. Now, what the Fitzpatrick case says is the entity must not base its assessment on stereotypes or generalizations, but rather must make an individualized assessment based on reasonable judgment that relies on the best objective evidence. So I want you to put yourselves in the shoes of Crabapple in this 2-day period and really think about what would you do based on the information that was given. So less than 2 days, again, before the trip, you hear from a teacher who's been going on this trip for decades and actually used to work on this trip as an employee. And she says very specifically, this student has difficulty with loud noises. He has to wear headphones in school assemblies and sit off by himself. He has sensory issues. He does not like to be touched. He doesn't like to be in close quarters with other people. She says that he needs a one-on-one aid, even in field trips. And you have her statement in the record, and it goes in much more detail than this about what her concerns were. But the bottom line, and she said this directly and very emphatically to Crabapple, that he should not attend the trip. She actually said that she thought it was extremely surprising that he would have been on the attendance list. And so Crabapple hears her out and thinks that what they're doing is concluding with her assessment and concurring with her assessment that it would be unsafe for him to attend. Now, first of all, going back to the Fitzpatrick case, this is an individualized assessment. They have the student's own teacher saying very specific things about what the concerns are. It is, better information than they could have gotten from any other source. And remember, this is not, this is just a company that's trying to run a rafting trip. They don't have access to this student's file. They don't know the student. They can't see the student. All they're relying on is the specific information and conclusion that the teacher is giving. It is a reasonable judgment. Going back to the second standard under the Fitzpatrick case, each of the issues that the teacher pointed out related directly to concerns that she had relating to the trip. So the difficulty with loud noises, the rapids are extremely loud, people are shouting. In terms of the sensory issues, you have to wear a wetsuit, it's cold, it's constricting, you're getting wet. In terms of needing a one-on-one aid, now no one was saying a one-on-one aid would be on the trip at this point, and one was never provided by the school. So if you don't have the one-on-one aid there to assist him and help, do what he needs to do to be a cooperative member on the raft, how is he going to function? What if he gets thrown out of the boat, which happens quite frequently, and is left on shore and has to wait for a long period of time? The teacher actually specifically said that she didn't think he could perform a self-rescue if needed, because, situationally, he might just not be able to do that. So because all of these concerns that she listed directly related to things that Crabapple knew were concerns and abilities that someone needed to have in order to be safe on the boat. And it's not just safety for the student. So if someone gets kicked out of the raft and they need a rescue, there's only one guide per boat. So if they had to attempt a rescue of the student, that puts all of the other kids on the boat at risk. If they had to mount a land rescue to get down to him if he made it to shore, there are safety considerations with that. Steep terrain, it's a long hike in, etc. So, these are middle school students they're talking about. So a heightened level of safety seems appropriate. And the other standard under the Fitzpatrick case is that it be the best objective evidence. So it's pretty objective when it's coming from a teacher. She sees him in a school environment under different sorts of challenges. He has worked with him for a couple of years, and she is expressing her concerns based on her experience. So while Crabapple did eventually over these 2 days hear from the parents didn't provide them with any specific information, just kind of conclusory information that they felt that their student should be able to attend. And, as this decision and this thought process was evolving over time, yes, it started to give Crabapple some doubts. Are we thinking in the right way here? Do we need to talk more with the principal, with the teachers? And they try to do that. So they talk to the principal at first. And the principal sort of just agrees with the whole assessment, doesn't say anything contrary. Then they hear from the parents. And again, the parents provide sort of conclusory information that they think their child can attend. And then later, they talk to the principal again. Now it's starting to appear like the student is going to attend. They express their concerns again. But at the end of the day, what happens is the principal emails and says the student will be attending. So first of all, what that tells me is the school did think that it was the school's final decision about whether the student would attend or not.
Ms. Collins, that's actually your time.
Okay.
And I apologize for interrupting you mid-sentence. I hate doing that.
No, thanks. I lost track.
Thank you, Attorney Collins. Let's see. I'll hold off questioning and invite Commissioner David. Do you have any questions for Attorney Collins?
Yes, Attorney Collins, you just said that the teacher, based on her, was in the position that had the most experience to make the judgment that she made that it was not a good idea for the child to go. I don't see any indication that the teacher has any experience in rafting at all. It seems that as though you're subject to the allegation that the teacher is basing that assessment based on her assumptions and prejudices about rafting and what those stresses would be and whether they're the same ones that go on in the cafeteria would go on in the rafting trip. I mean, it seems to me that there's complete individual reactions by an autistic kid.
Oh no, but she has attended this trip for decades. That's in her statement.
Okay.
So she's been on this particular trip. She's worked with this outfitter. She knows the trip quite well.
Okay, and you said they failed to provide a one-on-one assistant. They provide the father. What could be a better one-on-one accompaniment for the child than the father?
So Crabapple at first does not know that the father is going to be attending. So the initial assessment is made based on communication with the teacher. She doesn't say anything about the father attending. And that's when Crabapple says most, affirmatively, it wouldn't be a good idea for him to come. Later, they hear, this is about the afternoon before the trip, they hear that the father will be attending. And so that gives them a little bit heightened sense of comfort. You know, they start to make arrangements for if he does show up the next day, what they're going to do. And they went and got a different liability waiver that was more specific. And they actually arranged for a separate guide to be on the boat too. But a one-on-one aide and a father are very different in terms of, you know, the aide has certain training and skills. They didn't know, for instance, whether the father had been rafting before, had any experience, or would be sort of tied up in the rafting and not be able to be effectively, you know, there for his son. So that was a concern as well.
Well, you're saying that that would be a concern, that they would be making the decision that it wasn't appropriate for the child to come. And on the other hand, you're saying that this is a misunderstanding. They thought the school had already made the decision.
So what Crabapple was doing all along was giving its guidance and suggestion that he shouldn't come. And, you know, things did give them a little bit heightened sense of comfort over time. The father attending was one. And that's why by the end of the day, they just figured, you know what, the school's telling us he's going to come. If he shows up tomorrow, we'll be ready.
Thank you. Thank you.
Thank you, Commissioner David. Commissioner Doosan.
Here we go. I don't have questions.
Thank you. And Commissioner O'Brien.
I'm all set right now. Thank you.
I have, if I may, I did waive initially, but if I may, I do have a couple of questions. I'm interested in the timeline a little bit, Attorney Collins. As I understand it, the principal of the school, after the initial concerns were raised by the employee of the school, the principal of the school contacted the respondent and said that this child would be fine rafting, and that the parents had already considered these concerns, and that the parents themselves didn't have any concerns. Did that happen in that order?
There were two conversations with the principal. So the first one was almost immediately following the call from the teacher. So, you know, the owner of the company calls the principal, says, you know, I'm concerned based on what I just heard. I think it would be unsafe. So then there's some back and forth behind the scenes of the company between the parents and the school. And on the afternoon before the trip, there's a further call between the principal and the company. And that's when the principal is more asserting that he thinks it would be okay based on what he's been talking to the parents about. And, you know, then they get the final decision from the principal by email that the student will be attending.
And I understand that subsequent to that, there was no response from respondent back to principal's email first. Is that correct?
Correct. And the principal also didn't tell the parents that he had given that decision to the company.
And then, as I understand it, thereafter, was it the complainant's mother canceled a trip and complained, canceled a trip of her own and complained about this set of circumstances? Did that happen after?
No, that actually happened, I believe, the day before.
Well, I am confused about the timing. I understand that there was a responsive email from the respondent that indicated that they, and this is a quote in the investigator's report, "We based our decision about your son not being able to raft on information presented us by professionals." Was that responsive email sent before or after the respondent had learned that the parents and the principal believed the child could in fact attend this trip safely?
That was before. So it's, again, this is an extremely tight time frame. So this is all on the same day, June 6th, which was the day before the trip. So in the late morning or early afternoon, the mother cancels the other trip, and the company manager, the scheduling manager says, you know, we base this on information from the school. And then later that day is when they have further conversation with the principal and ultimately receive the email that the student will be attending.
Okay, thank you. Does anyone else have any further questions? Okay, we now turn our attention to the complainant. I have to confess, is there counsel for complainant? I didn't know.
Yes, Peter Rice is here.
There we go. Hello, Attorney Rice.
Yes, I should say that Mr. Endy, who appeared for the complainant at the fact-finding conference, is no longer employed by Disability Rights Maine. He left at the beginning of the year, so I have taken over the case.
Excellent. You have 10 minutes.
In Mr. Endy's stead. I hope I can do him justice as well as Mr. O'Donnell. The child in question here is an 8th grade student with autism. The school entered into agreement to have a rafting trip scheduled, and the trip got scheduled for June 7th of 2019. Then on June 5th, 2 days before the trip, the teacher contacted on her own the rafting company and expressed misgivings about the child being able to attend. This was not, and then Mr. O'Donnell, the child's father, talked to the school, talked to Crabapple Whitewater, explained to them that the child would not pose a problem, explained that he would be going. I think it's important to understand that the father never would have signed that if he thought he was endangering the life of his son or endangering the safety of others. So, and he knows his son better than anybody other than the child's mother. He was confident. He had been on rafting trips before. The child had gone canoeing with him multiple times for long periods of time without incident. And then, of course, Crabapple was concerned. The father called Crabapple, told them the school contacted Crabapple, told them that, and the principal is really the one that speaks for the school. He said that, in his opinion, the child should attend. And then later that day, in the words of in the sort of infamous phrase from the 70s, we have a smoking gun. Mr. Ashby just read, or Commissioner Ashby just read portions of an email from Crabapple. We base our decision about your son not being able to raft. Can you be any clearer than that? On information presented to us by professionals at Mount Blue Middle School, you're correct. We're referring to Crabapple Whitewater. We, referring to Crabapple Whitewater, have not met your son. We are not making generalizations. No, of course not. They're relying on what other people with disabilities who have taken this rafting trip, on what a third party says. That is the definition of generalization and stereotypes. The Maine Human Rights Act, requires an individualized assessment. Crabapple did not engage in that assessment. They did not meet the child. They didn't do anything to try and address the issues raised by the teacher. As a result, the father took the son on a separate rafting trip. And we would suggest that what Crabapple did was textbook disability-based discrimination. And so we would urge you to vote reasonable grounds. Thank you. I'm obviously happy to answer any questions that you may have.
Thank you, Attorney Rice. I'll hold off and invite Commissioner David. Do you have any questions of Attorney Rice?
Yes, as I was listening to Commissioner Aspey's attempt to clarify the timeline with Attorney Collins, I thought I was hearing that it's after that the last communication is by the complainant saying he's coming. Why didn't he go, if that's correct?
He didn't go because Crabapple told his mother, we are basing our decision about your son not being able to raft. That's a no.
But is that before the principal says he's coming?
Well, certainly the father is entitled to rely on that in terms of I don't know offhand. I'd have to go back and look through the exact what time because this was at 12:06 the day before, and what time the email from the school was. It is in the record. I don't have that right in front of me, but certainly Crabapple saying we are basing our decision not to allow them to raft is a no. I mean, that's pretty clear.
I hear that. I hear that. So if that's clear that that's the decision and they accept that as the decision, then why do they communicate that he's coming anyway? If it's after that. So it's still confusing to me, but I agree that when they say our decision is they're accepting responsibility for the decision.
Right.
So I would just, I'm sorry to interrupt. I would just note that Mr. O'Donnell was unmuting and I got the impression that he wanted to perhaps be involved in the answering of that question, but I wanted to, it's a little confusing when we have two people here for a party. So I just wanted to let Mr. Rice know that and let Commissioner David know that. We don't usually take testimony at a hearing. So I just wanted to sort of bring that up.
If Mr. O'Donnell wants to speak, that's fine by me.
Yeah, and part of the reason I didn't know if it was helpful or appropriate because Peter came into the case later, that there may be some info he's catching up on. So answer Commissioner David's question. I never knew anything other than this email was my last communication from Crabapple or anyone. So I never knew there was even a possibility that he could go. In my impression, and I was going back and forth with the principal through the day, while I was starting the principal, he at that point had also not heard that from them. Like he said in his email, he's going. But again, in other emails that are in the, in the papers there, the principal was not under the impression that it was his decision either. He was trying to get a hold of Crabapple, trying to get them to confirm, oh, I hope they will allow this. So this is around the time he also, they're saying, he said, oh, this student is going. He was trying to get them to allow it as he put it. So if that helps.
Okay, thank you.
Let's see. You all set, Commissioner David? I see you nodding your head yes. And now Commissioner Dooson. Questions for Attorney Rice?
Yeah, the timing here is really important. And I just, for clarity, the email from Crabapple saying he's not going is before the offer through the school of the father going or after?
You say that again, I didn't understand.
Well, I'm just not clear if Crabapple was aware of the offer of the father to attend prior to the email saying he could not attend. So I'm just trying to get clear at what point in the negotiations are they?
Yes, he spoke with Crabapple prior to that and told them that he would be attending.
Okay, so the email is after. Okay, gotcha. Thank you. I'm all set, Mr. Chair.
Okay, great, excellent. And Commissioner O'Brien.
Thank you. I basically had the same question as Commissioner Dooson, so I'm all set. Thank you.
Excellent, thank you. As I understand it, counsel for respondent has used her time. Is that correct? And so now we'll turn our attentions to the investigator.
Yes, that is correct.
Good morning, Commissioners. Yes, good morning. Just to cover a couple of issues here. Number one, I fully agree that the situation here was complicated by the lack of time to fully explore Sun's capabilities and possible need for accommodation. I would also agree, and that it's undisputed that the initial information about concern about Sun's attendance was raised by a personnel at the school that did have a prior relationship with the son. I think it's also clear that the owner subsequently had a conversation with the principal about Sun's participation, and that owner represented that at least at that initial point in time, the principal shared concerns about son's possible attendance. However, regardless of those communications, it's undisputed that on the day prior to the trip, both the father as well as the principal unequivocally communicated to the respondent that they believed it was safe for son to participate. So any prior discussions should have been allayed at that point once the two people presumably in the best position to gauge son's capabilities communicated that they no longer had concerns about his attendance and that father would be attending with the son. So I don't think any of that is disputed. With respect to the timeline queries that were posed earlier, it was my understanding that father had communicated with the company and was told unequivocally again that the son would not be allowed to participate. It was at that point my understanding that the father contacted the principal and said, "What's going on here? The company just told me that you made the decision that son could not participate." It was at that point that principal responded to father and reiterated that he had sent an email earlier that day that had been quoted earlier regarding that he believed it to be fully safe for son to be participating and that father would be accompanied. And it was at that point that the mother contacted the company to cancel another rafting trip that she had planned for later on down the line because she believed it to be unfair that her son was being excluded for undue reasons. And that was the responsive email quoted earlier, where again, the company said, we based emphasis mine, our decision about your son not being able to raft on information presented by professionals at the school. And again, they included this statement, we are making decisions on past experience with guests that are exceptional, that have attempted the same adventure with their family, and it has not worked out. So it was clear in this case that they based supposedly their decision on the initial information provided by the school coordinator, as well as their past experience based upon other guests with unknown disabilities that may or may not have been similar to complainants. So while respondent seeks to have it both ways that they never made the decision, I believe the email clearly speaks for itself that ultimately they made the decision about whether or not son could safely participate. Owner reiterated that at the fact-finding conference that despite all these sources of information, that ultimately it was his decision to make about whether or not son could participate or not. So again, in this particular case, it really comes down to who was in the best position to make a decision about whether son could safely participate. The original teacher, who was referred to as coordinator in the report, who expressed initial concerns, or principal and father, who later communicated to the company that they believed he could safely participate. And again, in this particular situation, although respondent claims that they took the principal's last email as an indication that son would participate and they were allegedly preparing for that event, they never communicated that to either principal or to the father. They would have no reason of knowing this decision had not definitively already been made. So at that point, deciding to allow son to participate on the trip, but not communicating that to anybody, essentially left them with the reasonable conclusion that he would not be allowed to participate. That's all I have.
Thanks, Bob.
Thank you. Thank you very much. Folks, does anyone have any questions for Bob? Commissioner, let's see, let's try it with Commissioner David.
You know, Bob, I think you just answered my question. The claim that the respondent was making arrangements for another liability waiver and for another guide to accompany if the child showed up, those were never communicated. Is that correct? And if they were not, okay, Yeah, you're saying that, yeah, go ahead, I'm sorry.
No, that is my understanding as well, that while they did indicate at the conference that they had begun making contingency plans in the event that the father and the son arrived, there was no response to the principal's email expressing his confidence that the son could participate, nor was there any email or communication back to the family telling them that these contingencies were in place.
Good, thank you.
Commissioner Doosan.
Yes, hello, Bob.
Great to see you again, Jeff.
Good to see you. Good to be seen. So in looking through the files a couple of times, looking for the required individualized assessment here, there is not a individualized assessment, nor was there a claim by the respondents that they had conducted such an assessment. I read their response that their decision is based on information presented by professionals at the school to mean the email provided by the teacher and the early stage communication, not quite as direct, from the principal.
Well, there were actually conversations. The person who's been referenced here again as the teacher was listed as coordinator in the report. Apparently, there were allegedly a couple of conversations between coordinator and various management officials at respondent's company about the son's capabilities and likely reactions to the trip. So again, I think that there certainly was information gleaned from those conversations where at least some information was taken into the later assessment. In this case, however, again, that while that may have been considered an assessment if viewed in isolation, it fails to acknowledge the subsequent communications by both father and principal that contradicted coordinators' concerns about son's abilities.
Okay, I just want to make sure I had the timing together here. And so again, I'm understanding that the final communication received by the family and the principal from the respondent was that the student may not attend.
Well, again, aside from the principal's last communication in the email wherein he had indicated that he was in favor of son's participation, you're right. There is nothing in the record to indicate that respondent actively contacted anyone else after the principal's email had been sent.
Thank you very much.
Investigator, how about Commissioner O'Brien?
Thank you. I think I do have one question. It's somewhere I read that the respondents did provide other. Well, I don't know that they call it accommodations, but that if he didn't go on the trip, he could do other things, swim, whatever. To me, I mean, are you saying at no point that whole thing was communicated, or that it didn't matter?
Sure.
Okay.
Yeah, my understanding is that they did offer to have son participate by having lunch with his classmates and swimming, which was a later component of the trip. But again, to me, this is largely like saying you can go to Disney World, but you can't do any of the rides. We'll meet up with you at lunchtime and sing songs on the bus ride home. But again, to somebody that was looking to actively participate in this once in a lifetime class trip, being told that you could attend lunch and go swimming later on, but miss out on the adventure itself, really, I didn't consider a reasonable accommodation, but there is no doubt that that was, in fact, one of the offers respondent made.
Okay. But am I not muted? Am I muted?
Nope,
no.
We can still hear you.
Okay. but I guess my point is, somehow it seems to indicate to me that the respondent that the respondent was making accommodations, I get, assuming that he was going to come. I'm not saying that those, I tend to agree about the Disneyland analogy, but I guess what I'm saying is it appears that they assumed, they took on the responsibility. So you just made that great analogy, but I just wanted to be clear that all of that conversation was not relayed to the parent, to the claimant.
Well, actually, I believe that offer was communicated, but that again, subsequently, mother sent an email to the company wherein she had canceled her other trip. And at that point, again, there was no indication from mother that they were considering this other quote unquote accommodation. At that point, it was clear. Mother said that she was canceling her trip because they would not let their son raft. So there was no equivocation at that point that he might still be going to do this partial adventure. It was clear at that point that mother was accused in the company of making generalizations about her son's capabilities, and that was the reason why she was canceling her own trip. So there would have been no reason for the company to have assumed at that point the complainant would be participating in any level of degree.
Okay. Thank you. I'm a little concerned about that. Okay, I'll leave it at that. Thank you.
Okay, anybody else have questions for Mr. Beauchesne? Hearing no more questions, I think we're ready for a motion. There is one finding here by our investigator, one recommendation that there are reasonable grounds to believe that respondent discriminated against the complainant on the basis of disability and that conciliation should be attempted. I'll entertain a motion.
So moved.
Moved in support of the recommendation and seconded. Any discussion?
Yeah, I'll go ahead, Jill.
No, I'll wait for you, Commissioner Davis.
Yes, I mean, I've seconded the motion. I intend to vote for it. There are two significant factors. These so-called offers, as were referred to for accommodation, are worse than not letting the kid go, in my mind. That you can go, but you can't be there for the adventure. You can show up later because you're disabled, and so you can have lunch at the end of the trip. That kind of thing. But the business about preparing a liability waiver and for another for another guide on the part of the respondent is an indication, and not communicating that is an indication that they respondent know that they have made that decision. They're preparing for a confrontation if the child shows up. It might have been a reasonable accommodation for the respondent to communicate and say, listen, we have these concerns. Would you consider a stronger liability waiver for those concerns? But they didn't do that. They had sent the email that he's not going, and they never took that back. They never yielded to the authority of the principal. So I think there was discrimination.
Commissioner Dusson.
I agree. Thank you, Commissioner David, for laying that out so clearly. I keep reminding myself, and I've written it here, so I remind myself every time that what we're looking for here is this at least an even chance standard that complainant might be successful. Here, the offers are only an accommodation if the complainant is aware of them. And it just seems clear that the complainant was not aware, the parents were not made aware that in the final analysis, the young student was going to be allowed to go on the rafting trip. Indeed, they confirmed to the complainant that he would not be allowed to raft and stated the rationale to support that decision in their last communication to the family. So I think that the reasonable grounds are well laid out and that the commission should support these findings.
Okay, any further discussion? You're lighting up, Commissioner O'Brien.
Oh, I didn't realize that. I didn't raise my hand.
You don't have to. You don't have to talk.
No, I know. I'm still somewhat uncomfortable, but I absolutely agree that I don't see that because they were offering those things as a confrontation. I see those things. I see those accommodations, including the additional guide and all that, as saying, okay, we're communicating here. We're gonna have. We'll make some. Let's continue. We'll continue to talk, but then didn't do that. If I'm making myself clear, I think that those are very important, and I think that had this, except for the fact that the communication didn't keep going, it appears that yes, that yes, there was. Because of that, I think I agree.
Okay, thank you. All right, so there's a motion and it's been seconded that we accept the findings of the investigator that there are reasonable grounds. All in favor, raise your hand and say aye.
Commissioner O'Brien will need you to verbalize if you're voting in favor of this motion.
Okay. Aye.
Aye here.
Aye.
It's unanimous to me.
Okay. So the finding is reasonable grounds, and the commission will send a letter to the parties and council confirming that in the next steps in the process.
Great, thank you, Council. Now we have, last but not least, the case of MHRC number H20-0531 and HUD number 1-21-7725-8. That's Katie Willett versus Oceanside Condominium Association. This is also a reasonable grounds case, and as a result, we'll hear from the respondent first. Is there anyone here on behalf of?
Identify yourself.
Hi, this is Rich Pichet. I'm the president of Oceanside Condos Association.
And I'm a fellow board member, Allison Fairbanks. We will not be presenting an oral presentation to the commission today. We'll rely on what we have provided in writing.
Okay, I have one observation first, and that is that is it Pichet?
Pichet.
Pichet, I'm sorry. You appear to be on mute, but we can hear you. So I want you to know that we think you're on mute. You're apparently not. So be careful. Just be careful. That's all.
Thank you, sir.
All right. I don't. That's the first I've ever seen of that. But I rely very heavily on that red microphone myself. So that leaves us then with still the opportunity to question. Have you folks determined who will accept questions from us? I don't know that we have to limit it to one person, but we commissioners do have the opportunity to ask you questions.
I will be speaking.
All right.
On behalf of the board.
Okay, perfect. And that being the case, Commissioner David, do you have questions for Ms. Fairbanks?
No, I was expecting a presentation, but no, I did read it. I don't have any questions.
All right, thank you. Commissioner.
I do not have any questions, sir.
Commissioner O'Brien.
No, I don't have questions. Thank you.
I'm going to take just a moment. I've written notes. I want to take a moment if you folks will accommodate me before I decide whether I have no questions.
Of course.
Excuse me while I take a mouthful of breakfast off spoon.
Would never have noticed if you didn't say anything.
Yeah, go for it.
I guess I just have one question, and that is, what was the rationale behind communicating with all other property owners about this pending request for an assistance animal? What was the sort of rationale in the correspondence that says, quote, and I'm referring to page 3 of the investigator's report, "The board is taking all due diligence to protect the interests of all unit owners while in the process of making an informed decision."
All right, let me answer. Can you just hold on a moment? We're having back recording. We had gotten a number of complaints from other unit owners. It is virtually impossible to come onto the property for someone not to see an animal. And so it was to let the unit owners know we were aware of the animal and that we were dealing with the issue. We did not identify either the complainant or that it was an animal assistance claim. We were just making sure that all unit owners know we're aware of there being a dog on the property. That's it. We had no intention of identifying Katie or that it was an animal assistance claim. Those identifications only came from Katie later.
Okay, the investigator's report excerpts that correspondence. When you referenced informed decision, did the communication further explain what that meant?
No, it did not. And part of this was when I say that making all unit owners, the issue of pets on the property has been around for 40 years and has come up periodically. There are owners who purchased here because there would be no pets. So the president's understanding when he sent this out was, okay, we're just letting people know, we're aware of it, we're deciding, as a board, we're going to be looking at this, but in no way identifying, as I said, either Katie or that it was an animal assistance claim.
Okay, thank you. I guess I have no further questions. Now, Commissioner David.
Sorry, I'm sort of catching up in my own notes about the case. You knew from the time that she moved in that she claimed it was an assistance animal. And it's after that you're telling people that you're aware there's an animal and you're looking into it, right?
That's not quite accurate. They closed on their unit in June. There were several times because an animal was observed on the property. And at that point, they were spoken to, had no idea that there was going to be any kind of assistance animal claim. Obviously, when they moved in September, then the presence of a dog becomes even more apparent. Because as I said, it is impossible. All the front doors face the parking lot. So everyone basically knows anybody else's business. So this was just, yes, we don't want to keep getting, reports of the animal. We're aware of it. And we're also doing what we have to do to protect all the rights. This was not a situation of balancing. We were going to be considering Katie's request as Katie's request. And if she was entitled to have the assistance animal, then fine. On the other hand, we have unit owners who for years have been very concerned about not having pets on the property. We were trying to be very careful to not say anything beyond what we, should say, but at the same time, making the other unit owners at ease, like we're aware of it.
And when you say you are telling the other units you're doing what you have to do, that includes challenging in a very, very litigious sense your request for discovery about dates and statements from a breeder and that kind of thing. You're not accepting the surface letter that she gives you initially that says this is a service animal. Isn't that
well,
correct?
First thing, no one else in the condominium outside the board would have known about this, okay? Because they didn't know it was an animal assistance claim, all right? When we were asking, we clearly had looked at it as we were looking at the totality of the situation, and we're aware that there was an issue about there being a pet. And of course, because we have a no pet policy, we were trying to, on that issue, get clarification on what the situation was. There was nothing to be, okay, I'm sorry. Go ahead.
Also.
Oh, finish that thought, Ms. Fairbanks, if you want to.
I'm sorry, I have nothing further on that at this moment.
Okay. Anybody else have questions for Ms. Fairbanks? I'm not sure if we made it all the way through to Commissioner O'Brien or not.
Oh, Commissioner Doosan had her hand up.
I'm so sorry. I didn't mean to skip you, Commissioner Doosan.
Oh, I just want to be clear about the timing. During the time that you were engaged in verifying I guess I'll use the word legitimacy of the complainant's claim that this was a service animal, not a pet. During that time period, am I misunderstanding that the board was also discussing fines and other reactions to the presence of the animal?
No, we were not. We were looking for information during that whole period. There was no discussion about fines. We had not made a determination. Moreover, Katie was bringing her dog up on the property. We had not made a determination. So since we had not made a determination, nothing was done with respect to the imposition of fines. That was only done after the board made its determination.
And the board determined that it was a pet.
Determined that it was a pet, and that we also, the information we had provided did not establish that she had a disability, which took it into the emotional support animal realm. We had clear information that the dog was purchased before. There was nothing in the note from the nurse practitioner that indicated that she knew that the dog had been in existence before she even made the recommendation. They obtained the dog in February as a pet. Katie saw the doctor sometime in March. The note was not obtained in August. There was nothing to indicate that the doctor knew this was a pet and that this was, an accommodation was warranted. There was nothing. All we had was, there was a pet. And we certainly would have welcomed information to the contrary at any time. So for example, when we were provided an appropriate note from the nurse practitioner, we immediately granted the request made by Katie. The dog is now permitted on the property because we've accepted that it is an emotional support animal.
And all fines are rescinded.
And all fines, which when it was not clear, have been rescinded.
Commissioner Dusson, you all set?
Just not clear when the fines were imposed, but.
Okay, the fines, let me clarify that for you, okay? Just give me a moment, okay? If I could.
Perhaps I'm overthinking it.
No, that's fine. That's one of the things you get to do when you're the commissioner, you get to ask. Okay, let's see. I'm just, so I get the information right. There were, let's see. The request was denied November 23rd by the board, okay? By an email dated December 9th, the board advised Katie that it had received written complaints. At that point, we said that she was entitled to an opportunity to be heard on the issue of fines. Nothing was done until we had made our determination. And as I said, in fact, she was bringing the dog up. I should, to the condominium. I also should note, as it's in our documentation, this is not year-round residence. In fact, except we had one person, an 80-year-old woman with dementia, who lived here year-round.
My question.
Yeah.
Okay. But there was only one person year-round resident, okay? Everyone else is from outside Maine.
I think
So
Commissioner
unless
Dusson is
somebody was
encouraging
here,
I'm sorry. I think Commissioner Dusson is encouraging you to just answer her question about.
I'm sorry if I've gone beyond it, Commissioner.
Thank you.
My apologies.
Yeah, no worries. Thank you very much. I'm done.
Those were the dates.
Well, and although this is our second time through the list of commissioners, I will still give Commissioner O'Brien an opportunity. You have any questions?
Thanks. I just was struck by something that initially the animal was a pet. Am I correct? And then it was a pet, and then at some point it became a support animal, and I'm saying legitimately. Am I correct in that?
Yes, you are.
Okay. Thank you.
Thank you, Commissioner.
Where are we? Where are we in this process? Because I can't see. Are we now? Are we? Okay, we're still in the very beginning, hearing the respondents. Am I correct?
We're about to hear from the complainant, Commissioner O'Brien.
Okay. Yep. Thank you.
And as I understand it, complainant is represented by counsel. Is that correct?
That's right.
Attorney Smith, you have 10 minutes.
Excuse.
Oh, I'm sorry.
Standing from what we were sent, that if I did not make a presentation, that there would be no opportunity for the other side to make a presentation. That is what the paperwork said. I've only answered the questions, so there has not been, under your rules, an opportunity for Mr. Smith to make a presentation. That was only going to be if I made a presentation.
No.
So if I understand, you guys made a strategy decision not to make a presentation so as to deprive the complainant of the opportunity to respond. Is that accurate?
No, that is not what we did. We felt that what we had in the paper, in our documentation, was sufficient. If they had any questions about our documentation, yes, we'd be willing to answer it. However, we decided that the written positions were sufficient. It was not to deprive him of anything. However, under your rules, he is not supposed to have 10 minutes unless we exercise 10 minutes to make a presentation.
I'm going to let Commission Counsel field that one.
Sure, our rules provide that the party agreeing with the investigator's report doesn't make a submission, but can respond to submissions by the other side, because we do not allow those submissions in writing. The fact that you submitted a written submission stating your disagreement gives the complainant the opportunity to respond. So
may I just have a moment, because I just want to pull something up if I can.
I think it's actually up to our commissioners to make this decision, not necessarily to continue arguing it. So I think.
All right, well, I will have to take, I oppose it because based on what was sent out, it was not evident that that was the case.
In the
That
end,
it
we
was
raised these questions to the complainant.
I guess I would turn to the chair to determine the will of the commissioners at this point.
I would just like to chime in just to state that I do wish to present so I can respond to what was submitted to the commission in writing. Thank you.
I have a comment, Jeff.
Well, before you comment, Ed, I'm going to review only my opening statement, which I always understood was an accurate recitation of our rules, but I will tell you it's not very clear from the statement I offered at the outset before presentations were made, and that was that the relevant part is, the commission allows parties who do not disagree with the investigator's report to rebut comments made by the opposite party. I guess I'll entertain a brief conversation, especially in light of the fact that Ed has something to say before we decide what to do.
Yeah, what I have to say is that I think it's clear that he has the right to make a presentation, that what respondent did was a presentation in answering questions. And I think in response to Director Searson's inquiry, she's actually saying, yes, it was a strategic decision. We thought that what we wrote was sufficient, so we were trying to cut him off at the knees. He has the right to make a presentation.
My instructions go on further to say, please be advised that commissioners may ask questions. So it's not a surprise to the respondent that we asked questions. We did that pursuant to our rules, as I understand them. She made comments. That's factually accurate. And I interpret the plain language of my instructions, at least at the outset, to mean then that commissioners allow, or the commission allows the complainant at this point to rebut comments.
Ms. Fairbanks, no, just a minute, please. Just a minute, please. Our procedural rule, which is available to all the parties, explicitly states that the commission may allow the parties to make an oral presentation on information related to the complaint of discrimination. That's within your discretion.
Yeah.
Thank you for that. And I was putting a finer point on it to say that even as my instructions indicate, I think it's appropriate, and I do wish to hear from the complainant. I think it's appropriate that we do hear from the complainant. Mr. Smith, you have 10 minutes.
Okay, thank you. Tyler Smith on behalf of the complainant, Katie Willett. We're asking that the commission accept the investigator's report, which thoughtfully considers the evidence, which correctly analyzes the law, and then appropriately determines that Katie has at least an even chance of success on her claims. In September of 2020, Katie sent an email to the board. She wanted to make them aware that she had an assistance animal who would be visiting the property with her. She identified the assistance animal as a 17-pound Cavapoo puppy. She told them that the dog was house trained, that it was up to date on its shots, and that it had gone through training. She also told them that the dog's time in common areas would be limited and that the dog would be leashed. She attached 2 documents to her email. The first was the pamphlet from this commission explaining what an assistance animal is, what a housing provider's duties are in response to a request for an assistance animal exception, and then what can be requested by a housing provider when faced with a request for an assistance animal. The second was a letter from her healthcare provider, a nurse practitioner, and that letter explained 4 things. That Katie had been under her care since March of 2020, that the nurse practitioner was intimately familiar with her health history and familiar with the functional limitations imposed by Katie's chronic health condition. Third, the letter explained that to alleviate the challenges with that chronic health condition and to enhance Katie's day-to-day functionality, that an assistance animal had been prescribed. And then finally, it stated that the presence of the animal was necessary for Katie's health. So Katie did everything that the law required of her. She provided a note that established a disability. Now, the note didn't use the magic words disability, but the Maine Supreme Court, the First Circuit, and pretty much any court that's dealt with the issue has held squarely that requests for accommodations do not need to use any magic words. They only need to provide enough information to establish that the individual may be disabled. And that certainly is the case here, where the letter talks about functional limitations on Katie's day-to-day functionality. The note established that the assistance animal had in fact been prescribed by a healthcare provider. Then Katie's email established that Lottie was the assistant animal in question. Now, it doesn't matter that Lottie was first obtained as a pet. What matters is whether at the time of the request, which was in September, was Katie entitled to a reasonable accommodation and was Lottie an assistance animal at that time? It doesn't matter that Lottie had been obtained earlier. And if you think about it, it really makes sense. For many people, such as Katie, the benefits of having an assistance animal aren't known until somebody actually has the animal. And perhaps more importantly, unlike service animals, the service dogs, seeing eye dogs, things of that nature, you don't need a prescription to get an assistance animal. And oftentimes the only time that somebody has a need to actually get a prescription is when they're faced with a housing provider or some other need for a reasonable accommodation, and they need to substantiate that the animal is in fact needed. And that's exactly what Katie did in this case. She had a housing provider with a no pet policy. She got a doctor's note establishing that her animal was in fact or she had actually gotten it before, but she brought in a note establishing the prescription and evidencing it and providing it to the housing provider. Now, I think when you think about the facts of this case and listen to some of the explanations, I want you to think about who is actually analyzing this request. Mm-hmm. This condominium has had a no pet policy for nearly 50 years. And as the board made clear in its position papers to the commission, it has a steadfast history of denying requests for exceptions. The condominium consists of two buildings with little sound insulation. They frequently leave their doors open or their windows open for cooling. Some of the people purchased condominium units at this condominium specifically because of the no pet policy. And the board believes that apparently it would be an undue hardship and it would negatively impact the quiet enjoyment of all of the units if they allow a dog on the premises. So that's the context when you hear the board talk about protecting the interests of unit owners. Now, far from engaging in an interactive process, what the board did in this case is they started with a presumption of fraud. They state in their own position papers that they were aware, or at least they believed that there exists, a proliferation of fraudulent assistance animals claims. Those are their words, proliferation of fraudulent assistance animal claims. So as a result of that, rather than accepting a note from a medical provider, they propounded discovery requests that appear to be calculated to drum up evidence to deny the request. They asked for a signed statement from Katie's medical provider, detailing her medical history in the sense that it would require her to explain when she first started seeing the nurse practitioner, when the diagnosis and when the prescription was arised. She asked for a signed statement. They asked for a signed statement from Lottie's breeder. They asked for a copy of all vet records. And then they asked for all documents reflecting accommodation requests to another housing provider. Now, none of this had anything to do with whether or not Katie was an individual with a disability. And none of it had anything to do with whether a healthcare provider had prescribed an assistance animal. Now, later on, the board told Katie that it had the right to ask her these questions under state and federal law. Katie quite understandably asks, what are these laws and can you provide them to me? The board dodged that question and didn't answer it. The investigator in this case posed the same question to the board. The board's representative was unable to articulate what those laws or cases were, other than simply stating that we all must be aware that there are fraudulent assistance animal claims. Then on top of that, the investigator provided the board with over a week to provide citations. The board sent in a 5-page response that basically dealt with everything in the case except for the specific question that was asked, which is, please provide copies of laws, rules, regulations, case law, or other documents that respondent relied on in asking complainant for additional information in October 2020 about her personal information and information related to her assistance animal claim. Katie's first attorney wrote a letter to the board in November explaining that the board was violating Katie's rights and that Katie was entitled to have the assistance animal on the property. And the board responded to that about a week later with a letter denying the request, which accused Katie of not being disabled, stated that Lottie was not an assistance animal, stating that Lottie was obtained as a pet, and then noting that on 2 earlier occasions, before Katie even moved in to the property, that Katie had not alerted the board of the need for an assistance animal. Now, we heard some discussion about the issue of the board allowing Lottie to be on the property in February, after we provided some additional information in response to requests from the board. That change in course, doesn't erase what the board did earlier, which was still unlawful. Katie shouldn't have been required to forego enjoying her condominium while fines were being assessed. She shouldn't have had to deal with the emotional distress and aggravation of wondering if her investment in the condominium unit was wasted because the board was going to discriminate against her and prevent her from having her assistance animal on the property. She shouldn't have had to disclose additional personal information and additional medical information to get the board to give her the required accommodation. And then finally, she shouldn't have had to commit the time and legal expense bringing this matter all the way to the commission to get what frankly should have been granted as a matter of course back in September. And I guess I would ask you, just to sum up, what do you think is more likely with that specific issue? That the board had a sudden change of heart and decided that Katie was in fact entitled to have the assistance animal, or that it was a situation where the board is simply running damage control as this matter is being escalated through the Maine Human Rights Commission? And I guess I'll reserve, to the extent I have any time left, I'll reserve that for any further comments or questions.
Thank you, Attorney Smith. I don't have any questions for you. Commissioner David.
Attorney Smith, would you direct your attention to the retaliation finding in terms of the dates of her first saying that that she has the animal, and is it thereafter that she's assessed fines?
He was assessed fines after the board denied the assistance animal request. So that's when the fines were that's when the actual dates were for which they asserted fines. So the board, they go through this process of considering the request, they deny it in late November, and then they assess fines based on violations occurring after that date.
They deny it, they deny the request, and then they assess fines.
That's right.
Okay. And would you explain to me the difference between assistance and service animal? Confess I'm not up on that.
Sure. Now, A service animal is an animal that has been provided with training, with specific training to deal with a disability. And frankly, I haven't researched it in detail because this isn't a service animal claim.
Well, does it
But
make
normally you see
make any difference? Does it make any difference?
not for this case because
Not
it's
for
a lesser standard for assistance animals. One distinction is places of public accommodation. My understanding.
If I could, I'm sorry, if I could jump in, Ed, the assistance animal is a term specifically for housing. Service animal is a term expressly for places of public accommodation. They're different. All service animals can be assistance animals, but not all assistance animals can be service animals.
But this is housing in which you can't discriminate somebody that needs an assistance animal.
That is correct.
Thank you. I got it, Tyler. Thank you.
Sorry, Tyler, kind of my job.
No, you summed it up much better than I was about to. So thank you.
Commissioner Doosan, any questions for Attorney Smith?
Questions, Mr. Chair.
Okay, I think you said you have no questions?
I have no questions, Mr. Chair.
Great, thank you. And Commissioner O'Brien.
I thought I saw Commissioner O'Brien in person. I saw your picture and then it disappeared again.
Yeah, yes. We have a technician coming, but I think it will be too late. No, I'm sorry. I have no questions at this point. Thanks.
Excellent. And I have no questions. All right. So as I understand things, Ms. Fairbanks and the respondent elected not to make, at least initially, a recitation. However, in light of the fact that complainant did, I understand that there are 10 minutes on the books for the respondent in this case. And Ms. Fairbanks, if you would like to make at least to respond to what complainant has indicated here today, complainant's counsel has, we'd give you an opportunity to do so.
Oh, you're muted. You're muted.
Usually I have a paralegal who's remembering to do this for me. First, Mr. Smith made reference to that allegedly prior exceptions had been denied. This was in the history of Oceanside, the first time that we had a request for an assistance animal. It never come up before. That's number one. Number two, what we asked the nurse practitioner for was simply a date because it was unclear. The note was dated in August. It referenced March, did not say when in March. We were not looking for anything with respect to Katie's medical diagnosis. We knew that was private. We were not looking for anything medical. We were looking for a date. In fact, and with respect to the cases, and there was, in terms of the board relied on the fact, although at the time when it spoke to the investigator that there were cases, it was the fact that cases did not prohibit the board asking what it asked. We did not ask about her medical condition. We asked simply issues that went to timing, which was important in terms of our making a determination. Did anybody have anything else?
Well, all the fines were rescinded.
And that, as I said, all the fines were rescinded. The note that was received in February explained everything, including the fact that it was a pet. It became an assistance animal, and at that point we accepted it and rescinded the fines.
And we never cashed the checks.
And I have nothing further to add.
Thank you. I have no questions for you. Commissioner David. I see you shaking your head. No, Commissioner.
No.
Duke
No.
No.
and Commissioner O'Brien. I understand you to say no.
Hello?
Yeah, we're here.
I'm
Floor is yours.
back. I'm back. I do have a question, if I may.
Okay.
Thanks. It appears to me that this is because the association ultimately determined that it was a service animal, rescinded the fines. So basically, this is an issue of timing. Am I correct? From the time that from the time that she came in, from the time that she was originally until she was 5. She gave the first doctor's note. Am I correct? Or practitioner's note? Am I correct? And then you went further. So it's really a question of timing, because at this point, we're just talking now between those times, those months, ensuing months, because now you have agreed. I get this might be for Barbara or Amy, because I'm confused on that. So we're just concerned about was initially discrimination found. Am I correct? Because at this point it's not there.
Well, this is Amy, and I don't want to answer for the respondent. I would just say, from the commission's perspective, people file complaints here based on things that have happened. And even if those circumstances change afterwards, the respondent's act may still constitute unlawful discrimination. So the fact that it's been remedied doesn't mean that what might be unlawful didn't happen and impact the person who filed the complaint. It still happened.
Okay. And how this would affect her is that she did not, and this may be to the respondent. Are you saying that how this affected her is indicated by the fact that she did not bring her animal at some point, at some of her visits? Somebody about that. I don't think I missed it.
Well, I don't know if that was directed to me. You said to the respondents, she was bringing her dog up, and we base that only on people reporting us to us, up until at least into the end of December. After that, we don't know. People are usually not here in a gun quit in the winter time. And so, whether she brought the dog up with or without a dog, we wouldn't know.
Okay.
Because no one would be here.
Okay. Okay. I'm just trying to figure out how it did affect her, even based on what Amy just said. That yes, that initially you did request these things of her. Did that affect? What was that discrimination against her? I guess what I'm saying, and now let's go to the to the other side, perhaps, or maybe to Barbara. I'm not making myself clear. I can't see faces, but I assume what they look like.
This is Barbara. I think that the question that you're asking is of the complainant, but being familiar with the record, that is something complainant asserted, was that she did not come up as often because she couldn't bring her dog.
Okay, and that's her assertion, but there's no proof of that. That's what she asserted, and she did come up at other points with the dog. Am I correct there?
Again, at this point bow out because this is a factual question for, I
Yeah,
believe,
okay,
Attorney
okay.
Smith and complainant.
And the
Okay.
investigator.
Oh, well, of course. Sorry, Alice.
Okay. Am I just responding now? Again, I mean, I don't know who I'm asking at this point.
Well,
Amy?
where we are
I mean, are we just
procedurally,
yes,
where we are is that the respondent they finished their presentation, and so you had an opportunity to ask the respondent question.
Okay, so asking the respondent questions. Okay, perhaps okay. We haven't heard from the investigator. Am I correct?
We have not. We're going to go back to.
I did not miss that.
No, we're going to go back to complainant.
Okay.
If there's no more questions for the respondent, then the complainant has about 30 more seconds. And then if there's questions for the complainant, there'll be that. And then we'll hear from the investigator.
All right,
All right,
thank you.
thank
We'll
you. I
return-
just wait. Thank you.
We'll return to Attorney Smith. You do have 30 seconds.
And I did see Commissioner Doosan had her hand up, I would just say.
I'm so sorry.
I'm fine. And perhaps Attorney Smith can address it. It seems an important piece of the allegation of retaliation is the imposition of fines. Even if they were retracted later, they were imposed. And I just would like the complainant to include reference to that issue.
Okay.
In your 30 seconds, yeah.
I'll do my best. So with respect to the retaliation piece, the fines were eventually rescinded and they were imposed after she had already engaged in a protected activity. And it's really a straightforward application of McDonnell Douglas. Katie engaged in a protected activity. There was an adverse action, which was the imposition of fines, and then directing her, that basically coercing her from against bringing Lottie to the property. And then we had some evidence of causation just given temporal proximity. And for the board's part, it simply never articulated a lawful reason for its action.
I'm really sorry, but that was your 30 seconds.
Sorry.
Fair enough.
Sorry.
That does give us an opportunity to ask you more questions. I have none. Mr. David, Commissioner David. No, you're shaking your head no. Commissioner Doosan, shaking your head no. And then finally, Commissioner O'Brien. You're on mute.
I have no questions.
Okay, then at this point, we will hear from our investigator. That would be Investigator Alice Neal. The floor is yours.
Thank you, commissioners. Good afternoon. So the parties have addressed a lot of the things that happened in this case. I did just want to highlight out there in the timeline that, you know, the assistance animal was on the property and the board said you cannot have this animal. They made a determination based on their own assessment that complainant didn't have a disability, yet they've said they carefully walked the line to not ask her more questions about her medical issues, but yet the crux of the reason why they denied her the animal initially was because they said that they didn't think she had a disability. Those things are incongruous. So the timeline as I see it is she gave the condo association the information about her assistance animal. The condo association engaged in their investigation to figure out if the animal was a pet or an assistance animal. Ultimately, they denied that. The then attorney for complainant sent a letter to respondents and said, you're in violation of the law. Thereafter, complainant was fined at least 3 times, with one being held in abeyance. That might be wrong. There are at least 3 times that she was fined after the denial was done. 1 or 2 of those may have been held in abeyance because complainant had asked that with this case pending that she not be charged the fines. Complainant did mail in a check for 1 of the fines, and complainant did testify at the Issues and Resolutions Conference that she was unable to bring her dog and use and enjoy the premises to the full ability because she didn't feel like she could bring her dog with her, which does go towards the interference and retaliation claim that complainant has filed. So when you're looking at this for the 2 claims that are out there, the reasonable accommodation claim clearly was denied until respondent felt that they had enough information about the animal to then accept the assistance animal, which it doesn't negate the denial or the discrimination that happened. And then the second piece is the interference and retaliation claims. Some of those were fines, but there's also the fact that complainant couldn't have the full use and enjoyment of her housing because she didn't feel like she could bring her assistance animal. And she was credible in her testimony about that. And that is what I see whenever I look at this case. And I haven't heard anything to change my recommendations today, but I'm happy to answer any questions.
Just a minor point of perhaps correction, and that is I agree with your findings regarding retaliation on the issue of the fines. The decision by the complainant not to use her residence after the discrimination is probably not retaliation. It's an effect of the decision to deny reasonable accommodation, but I would argue that it's not an overt act on the part of the respondent. But I think you get there on the issue of the fines. What do you, in light of my sort of view, what do you think of that?
Well, I do think that respondents telling complainant that she would be fined if she brought the assistance animal with her when they had said it wasn't an assistance animal, and that she, in her own mind, felt like she couldn't go use her property, that is interfering with her right to enjoy her property and her housing. And it doesn't have to be there was just this fine. It's also her ability to use and enjoy the premises as a whole. And without being able to bring Lottie with her and feeling, and she testified that she didn't come to Maine sometimes and use it as the respite that she needed, that is interfering with her ability to use the place.
Thank you. That actually helps me. The suggestion that if she comes to use the facility, she'd be subjected to further fines is sort of helps me a bit with that. I was just wrestling a bit with that. Any other questions of the investigator?
Yeah, I had that same question, Jeff. Thank you, Alice, for the complete report and the history at the end. Very helpful. Thank you.
Commissioner Dusson, any questions?
I really appreciate the investigator's explanation in response to that question about retaliation. If we believe and there's the matter of credibility in the midst of all this, but if we believe the notice from the medical services provider that the presence of the animal is necessary for the health of Katie because its presence mitigates the symptoms she was experiencing, then to tell her that she may not, that if she uses the premises, she will be fined, I can make that leap to retaliation, because that is essentially saying you can't use the property if you bring the dog. Close to that, but so I think Katie could make those findings, could convince in a civil setting, could convince anyway, go ahead.
Thank you, Commissioner Dusson. Commissioner O'Brien.
This was whether there's any questions for Alice, I think. Is that accurate?
Questions for the investigator. Do we still have you, Commissioner O'Brien?
She's on mute.
Okay.
Yep.
Am I here now? I
you are.
really apologize. I have no questions, and I also thank the investigator. You cleared some things up. Thanks.
All right. Thank you. That means we have before us two findings. I interpret the recommendation that the matter be conciliated to be part of the findings. So there are two findings, reasonable grounds findings before the commission on which we can take a vote. One, that the respondent discriminated against the complainant on the basis of disability by denying a reasonable accommodation. And two, that there are reasonable grounds to believe that the respondent retaliated against the complainant for asserting her rights under the Act. Do I have
I'll move that we adopt both grounds, that there are reasonable grounds to believe that it was discrimination and that there was retaliation, and the complaint should be referred for conciliation.
Right, it's been moved. Any second?
I'll second.
Nope.
Okay, good.
Commissioner Dusson, seconded. All right, any discussion?
Yeah, speaking in support of my motion, I continue to be struck by the litigiousness of the respondents' questions of her. A copy of the veterinarian's records, said that they didn't ask for conditions about Katie's medical appointment, but they demanded a signed statement regarding the date of first medical appointment. It seems to me that, and then later on, there's an indication that they run an internet search. They are trying to prove that this is not a service animal in the face of that direct evidence and a statement from a medical practitioner, which is what the statute requires. That to me is evidence of discriminatory animus.
Any other discussion in favor of the motion? Hearing none.
Hello?
Go ahead, yes, please.
Well, just that I'm going to agree with it, although I don't have the legal teams of discriminatory animus. Is that what you said, Commissioner? I'll just say I'm going to agree with you.
It is. Their intention was discriminatory.
Yes. I see that. Thank you.
Okay, no further questions. No further comments on the motion. Then that being the case, I'll take a vote. All in favor of the motion, raise your hand and say aye. Commissioner O'Brien, just say aye or nay.
Yes.
Aye.
Yes, I'm sorry. I keep changing it up. Aye or yes.
I count 4 yeses.
Looks unanimous to me.
Yes. So both findings are reasonable grounds. And the commission will send a letter to the parties and council informing them of that and of the next steps in the process. We will continue to our statutorily mandated extortion process shortly.
Thank
you. That's gonna rankle for a while, Ed.
Come on.
That's gonna rankle for a long time.
I used to manage that process. It rankles me too.
I'm sorry.
Thank you, folks, for your contributions in that last case. You are certainly free to go.
Thank you. At this point, we would typically have, unless the commissioners want to take a brief break, we would have a motion to go into executive session with the appropriate FOIA language.
Pursuant to 1 MRS section 4056E, I move to go into executive session to consult with our attorney regarding pending and contemplated litigation, the legal rights and duties of the commission.
Second.
Moved and seconded. All in favor?
Yes.
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 I understand that we're going to get sent.
Yes. I neglected to assign you all. I'm going to do that right now. Just give me a second.
What will that do with Ms. O'Brien?
Well, it looks like she's going to get carried over. So, my lights just turned off because I'm not moving enough. It looks like I can carry over people on the phone too. So I'm going to now open up the executive session room, and you can't see us, Julie, but you should be swept over into that too.
Okay, great. Thank you.
Here we go. Oh, wait, did we vote? Okay, I've got Jeff, Ed, Jill, Mel, me, and Barbara, and hopefully in a second, Julie will be back. Although she doesn't have to be. Oh, no. Yeah, we don't have anything we have to vote on.
I don't, how does she do that on the phone? Does she have a
Well,
command?
I don't know, because I've never done this on the phone.
Yeah.
In theory, I think it should move her back in here, but I don't actually know.
I think it should too, but did you set it for a full minute? We probably haven't quite been a minute.
Can you set it for less than a minute?
Yeah, when I do my family mediations, I set the closing for 10 seconds is the shortest. There she is.
Here she is. Yes, it's good to know. I will set it for less time. Julie, you're back. Okay.
I'm here. I'm
So-
here. Thank you.
Yes. So I'm not aware of anything else that you all need to vote on or talk about. So unless there's something else, I think we're good to adjourn.
I'll entertain a motion to adjourn.
Oh, moved.
Been moved, second. I'll second it. And there's no discussion. We'll just vote to move. All in favor?
Yeah.
Aye. Thanks.
Bye, everybody. Thank you very much. It's been a day.
Be well.
Everybody.
Bye,
See you in
everyone.
June.
Thank you.
Everybody.
Thank you.
Thanks
Be
for
well.
your patience. Bye-bye.